My lord,
Yes, Mr.
may I be permitted? My lord, an appeal has been filed by the state of West Bengal. My lord, paper books have been served, but the petition of complaint is not there. So, my lord, let it come up as to be mentioned so that the department can file a supplementary.
Let's see.
With the leave of my lord justice,
To be mentioned. I'm deeply obliged.
I got 3 applications for substitution in connection of the content. The order passed by the Honorable Chief Justice Mishra with my lord.
Will it come up before this bench?
Bail in connection with appeal.
That's a bail in connection with relaxation. Well, anticipatory bail, my lord. Urgent anticipatory bail. I've indicated the number, my lord, in the text.
All these will come up tomorrow.
Please, and we are notifying the state also that
Tomorrow.
obliged.
Whatever anticipated will
Anticipate.
whatever was I won't give me. My lord, I am second time, my lord, mention this matter, but till now not in the list, my lord, relaxation, my lord. You don't know. And my lord, one admission of appeal, my lord.
Relaxation of condition of
Your lordship, correction of our order.
bail in connection with appeal.
My lord, bail in connection with appeal, my lord, this is pending as under the heading appeal hearing in the list. My lord, 5.5 years in custody.
Admission of appeal.
I'm grateful, my lord.
Lordship, may I have the leave to mention one bail in connection with appeal. Bail in connection with appeal, Lordship.
Bail in connection with appeal. Relaxation of bail.
Chota came in the morning.
Right one. John Shepherd. John Shepherd.
হ্যাঁ বলছি যে মিলর্ড আপনি একটা 2016 সালে একটা মামলা পুলিশ ইনঅ্যাকশনের মামলা হয়েছিল, সেটা কন্টেম্প করা হয়েছিল 2018-তে। মামলাটা এখনো পেন্ডিং হয়ে আছে আপনার কোর্টে।
Single bench?
বিষয়টা কন্টেম্প ফাইল করা হয়েছিল।
সিঙ্গেল বেঞ্চের মামলা?
তার সিঙ্গেল বেঞ্চের মামলা দীর্ঘদিন ধরে পড়ে আছে।
জানি না, দেখতে হবে।
2015 অর্ডার, তারপর আপনার কাছে আসা হয়েছে।
ঠিক আছে, কল দ্য লিস্ট। One.
Office report, call for an office report where, and last time, my lord.
Huh? কি হয়েছে? What is this case? কমপ্লায়েন্স রিপোর্টটা কই? কমপ্লায়েন্স রিপোর্টটা কই? Next matter. Forwarding letter. There's no complaint.
Thing, my lord, is that POXO space. Now,
Yes.
we had a meeting with the Registrar General, my lord,
Structure matter.
My lord, item number 4, my lord, and for the petitioner, my lord, we received the entire order sheet, my lord, yesterday. My lord, we need 1 day, my lord, to prepare the supplementary. Only, my lord.
Wednesday. Report is placed on record on the prayer of petitioner adjourned Wednesday.
I'm grateful, my lord. I'm grateful.
Next.
It was adjourned for custody. Now I am in custody for 71 days. Nothing has been
Petitioner is in
recovered.
custody for 71 days. No narcotics was recovered from his possession. He placed for bail and a lawyer for the state produces case diary. We have considered materials on record. No narcotics was recovered from the petitioner. His complicity from statement of co-accused. So complicity allowed.
Great.
Next.
Special court NDPS.
Six and seven, my lord, I am appearing for the petitioner. My lord, on last occasion, your lordship please to direct to file, my lord,
Submit my lord report.
chemical report, my lord.
Chemical report is placed on record. Samples tested positive to ganja. Statements of witnesses and contemporaneous document, that is Caesar memorandum, show recovery
40 kg.
40 kgs.
Yes.
40 kgs of ganja from petitioner and co-accused.
Yes.
In view of the aforesaid and aforesaid circumstances and statutory restrictions at 7 of NDPS Act, we are not inclined to grant it. Next. 7. What is 7?
My lord, the
Same.
co-accused.
Act. Next. 8.
Well, it was adjourned for the chemical report.
Chemical report is placed on record. Samples tested positive to codeine phosphate.
No, Gaja, 90 kgs.
Quantity.
90. 90.
Statements of witnesses and contemporaneous document, that is Caesar memorandum, show recovery of 90 kg ganja from the
Joint possession.
residence of the
No,
petitioner.
my lord. From a car.
From a vehicle. Petitioner was present in petitioner and co-accused were present in the vehicle. Under such circumstances, there are prima facie evidence with regard to conscious possession of narcotics above commercial quantity. Accordingly, accordingly, bail prayer is rejected.
But I'm in custody for about 10 months.
All right. Next. Conscious possession of
But on the
statutory restrictions with regard to bail on
NCB দেখছে না।
Yes, next matter.
On the ground of inordinate delay, I have come before your lordship. 7 years.
7 years.
My lord.
Mr. Deputy Solicitor General.
My lord had directed me to prepare a report and file it before your lordship, but it was my folly, my lord, because we went to the NCB, but the matter is not
Customs.
It is customs, my lord. So we have, my lord, the report has not come in a comprehensive form,
When
but
do
we
you
have
want?
come, my lord, 15th of this month is again fixed for cross-examination of other witnesses.
Already
Because
keep it after
already-
15th.
My lord,
We
after
keep it
15th,
after 15th.
my lord, after 15th, my lord, because I think so by then the other
7
witness.
years, 2 months.
7 years, so another 10 days you wait. Today we are 1st of April, we keep it after 15th, all right?
I'm grateful, my lord.
Mr.
Dheeraj
Trivedi, we are keeping it on 17th of April.
Lordship.
Deputy Solicitor General with Ms. Kundalia appears.
Huh?
And submits date has been fixed for cross-examination of witnesses
Well.
on 15th of April 2024. Under such circumstances, we adjourn the hearing of the bail
My lord,
application.
may I pray for one more indulgence, my lord? My lord,
Report
because
be
Madam
filed on
Kundalia is appearing with my lord, we regularize her appointment because it was my lord's, my lord had
request-
engaged me, my lord, because nobody was appearing, my lord.
We
So, my lord,
request so and
because
so,
she normally appears for the department, my lord. So,
we request the
Raj Kundalia.
no. We are saying Whom should we give the direction to?
My lord, to the,
Air intelligence unit, my lord.
They will regularize. We request the air intelligence unit to regularize the,
Report customs.
give the slip, give the name of the authority in a slip, to regularize the appointment of so and so in the matter.
I'm grateful, Lordship.
Report.
I love this.
We were, because Ms. Kundalia was not there. That's why we asked you. Otherwise, we know customs, she is
My lord,
representing.
and I also did not know whether it was by under the NCB or customs, my lord, so that. My lord,
Her husband in the farm.
Report.
Doesn't know. That's moving. And this one. It is, I think, customs.
My lord, may I please your lordship, my lord. My lord, on the basis of the statement made by the accused, the name of the petition, my lord, appear. Petitioner was phone arrested, my lord, 1812. Nothing was recovered from my possession of the co-accused.
Yes, Mr.
My lord, this is a
Bodhidhar.
cross-border trading, my lord. The consignment was going from India to Bangladesh. 3 persons were apprehended by BSF.
Yes.
My lord, this person, he along with Riajul, they are the supplier. Riajul filed an application for anticipatory bail. That was turned down. Still, he is absconding. My lord, the main persons, this Riajul and this petitioner.
All right.
And my lord, the second thing is this, your lordship will find. My lord, the antecedent, my lord, he was arrested in connection with the case of 2527 Arms Act.
He was already on-
Subsequently, my lord, because we could not find him out, my lord, trace him out, my lord, then we, my lord,
Where is your report?
my lord, this is the report.
Give the report.
my lord, he has already released on bail in other cases, my lord.
Very good.
My lord.
And further investigation is still going on because Riajul
That
is,
other person.
yes, my lord, this person and Riajul, my lord, they are the main person who supplied the entire consignment.
Nothing was recorded, my lord, on the basis of the
How can
statement
it be
made by the
recovered? It cannot be recovered, my lord.
one of the accused person, Aminur Mandal, has already released on bail by your lordship. my lord.
Petitioner submit, he is in custody for
3 months, 15 days.
115 days.
Yes.
105 days.
105 days.
105 days. No narcotics was recovered. Investigation, so far as the petitioner is concerned, is complete. He prays for bail. Learned Deputy Solicitor General opposes the bail prayer. He contends petitioner is a member of a gang involved in trans-border narcotic trade. Narcotics above commercial quantity was recovered from co-accused
No, accused Aminur Mandal, man. Aminur Mandal.
from co-accused
From 3 of them, my lord.
Ah.
Already on.
Aminul Mondol, Biki Balla Mondol,
Please
and
wait.
Hirikul Kaji.
co-accused Bikiballa Mondol, Torikul Gaji, and Aminur Mondol. Full stop. Their statements in the course of investigation, complicity of petitioner and co-accused Din Islam Ghazi, co-accused Riajul Ghazi transpired. Full stop. Petitioner was arrested, but Riajul Ghazi is still at large. Investigation is in progress to apprehend the absconding accused. We have considered the materials on record. Narcotics above commercial quantity, that is 450 bottles of fencetrol syrup, was recovered from Baki Billah Mondol, Torikul Ghazi, and Aminur Mondol. Full stop. During investigation, in course of investigation, statements of the said co-accused were recorded under 67 NDPS Act. This disclosed these statements disclosed involvement of petitioner and Riazul Ghazi as suppliers of the cough syrup. Full stop. Petitioner was apprehended and is in custody for 105 days. No incriminating material, no narcotics or any other incriminating material has been collected while through custodial interrogation. Full stop. It is tried statements of co-accused under section 67 of NDPS Act are inadmissible in law. In view of the further investigation is in investigation so far as the petitioner is concerned is complete. Further investigation is in progress to apprehend co-accused. Under such circumstances, we are of the opinion further detention petitioner under such circumstances, we are of the opinion in view of scanty materials on record disclosing involvement of the petitioner in the crime. He has been able to rebut the statutory restrictions under 37 of NDPS Act and may be released on bail subject to conditions. Petitioner, while on bail, shall remain within the district of North 24 Parganas and report to the Narcotic Control Bureau once in a month, and Kolkata Zonal Unit once in a month until further orders. Hello. এই যে এইখানে আছে, রিপোর্টটাই আছে। Narcotics. Sonali Das.
Yes.
No
I'm
seizure from the petitioner. His implication is from the statement of co-accused. From the house of one Shubhankar model, seizure was effected. Charge sheet
But
submitted.
criminal antecedent is there. There are 4
Already.
cases pending against this
So
petition.
petitioner is in custody for
170 days.
170 days. No narcotics was recovered from his possession. He co-accused are on bail. He prays for bail. Learned lawyer for the state submit petitioner as criminal antecedents. We have considered the materials on record. Petitioner is in custody for
170 days.
117 days. No narcotics was recovered from his possession. His complicity as co-accused. Full stop. Under such circumstances, we are inclined to grant bail, subject to conditions. Meet officer in charge,
Charge sheet.
Charge sheet submitted.
Hilly Police Station.
Wait, next.
Yes.
No recovery, custody for 240. Principal accused, 245 bottles of cough syrup was fentanyl was recovered from Shahrul.
Yes. No recovery.
Person who was granted bail is not the principal accused, he was a minor boy. The minor boy was playing with his friends when this man gave the packet and certain amount of money, asked him to cross the border. Malad, the statements of those friends
Alright.
has been, is there,
Petitioner is in custody for 2.5 years.
and there are, and
40 days.
there are.
Why you had absconded?
of this man.
Yoshi, I was arrested subsequently in connection with another case.
You
Thereafter, I
were
was shown arrested.
423, he was shown arrested. And there are antecedents also.
No, the other person was in custody for 2.5 years.
From him, recovery was there.
All right. So what is the complicity?
Honorable, can you look to page 14 and 15 once?
Petitioner is in custody for 240 days. He submits co-accused is on bail. He
I'm not on that ground. I'm only on the ground of no report. I'm not on that ground that co-accused has been granted bail because from his
no recovery was made from his possession. He prays for bail. Learned lawyer for the state submit petitioner had handed over. Lawyer for the state submit petitioner has criminal antecedents. He had handed over the sack containing fentanyl bottles to co-accused
Minor.
Shahrul Mondol, a minor bracketed, who is presently on bail. Petitioner presently on bail, full stop. We have considered the materials on record. Statement of witnesses show petitioner had handed over a sack to the co-accused, a sack and some money to the co-accused. Thereafter, he was apprehended by BSF personnel. From the sack, fentanyl syrup was recovered. These materials,
report is possible.
fentanyl syrup was recovered. These materials prima facie show petitioner had abetted the transportation of narcotics above commercial quantity. He is in custody for 240 days. Co-accused, a minor, was released. Co-accused was released on bail after incarceration for 2.5 years. Under such circumstances, we are not inclined to grant bail to petitioner at this stage. Trial be expedited. Next.
I picked a appear on behalf of the petitioner. Total 2 kg gaja was recovered from the joint possession of two persons.
Then what recovery took place?
Total 2 kilograms ganja from
Then-
each one. Thereafter, they
Gas from the 2% blood.
Huh?
Near a petrol pump, they are moving
2 kgs.
2 kg only from 2 persons.
In all 2 kgs?
yes.
We have considered the materials on record. Quantity of narcotics recovered, that is 2 kgs of ganja, is below commercial amount of narcotics is below commercial quantity. Petitioner is in custody for
39 days.
for about 40 days, balancing the nature of accusation with the period of detention. We are inclined to grant bail.
Chassis notice.
Uh, 2 years, 7 months, 2 years, 8 months. Right now I am in custody, my lord. And no witnesses have yet been examined. And out of 8.
The next date is fixed on 15th of May 2024.
Petitioner is in custody for 2 years, 8 months.
The presiding officer is not there, my lord.
He submits there is delay in trial, he prays for bail. What is the allegation in the,
My lord, 2.5 kgs of codeine mixture was
yes,
seized from his
where have you
exclusive possession.
stated what is the allegation?
My lord, para number 2, my lord, I have stated.
We learned lawyer for the state submit delay is due to absence of presiding officer in the court. We have considered the materials on record. Though 2.5 kgs of codeine mixture was recovered from petitioner, he is in custody for 2 years and 8 months. Witness examination of witnesses have not commenced as yet. Delay in the matter is not attributable to the petitioner. Under such circumstances, fundamental right of the petitioner to speedy trial has been infracted and he is entitled to bail on his court. Bail prayer is not allowed. Next.
I know, my lord.
Understood. We are of the opinion. Next.
On 4th of May 2022, this Honorable Court in a revisional jurisdiction directed the trial to be completed preferably within 1 year. That order was communicated on 11th of January 2023. Till date, out of total 9, only 5 witnesses has been examined. I am in custody for more than 2 years, 9 months. From 6 person, total 50 kgs of gaja was recovered. My prayer for bail was rejected in March
My
2022.
lord, only 4 is remaining. Within 6 months, we will complete the, my lord, evidence of the 4 witnesses.
Give a report. Petitioner is in custody for 2 years, 6 months. 9 months. He submits in spite of direction given by this court to conclude trial within a year in 2023.
January order was passed May 2022. It was communicated in January 2023.
Which was communicated to the trial court in January 2023. Trial has not come to an end. He prays for bail. Learned lawyer for the state submit. 5 witnesses have been examined.
Examine, my lord, 4 left.
5 witnesses have been examined. He assures the court that remaining 4 witnesses will be examined within 4 months. We have considered the materials on record. 500 kgs of ganja, 50 kgs of ganja was recovered from petitioner and co-accused. This court in CRR, where is that CRR?
Page 16.
This a learned single judge in CRR 1396 of 2022, bracketed vide order dated 4/5/22, directed completion of trial, preferably within 1 year from the next date of year. Though petitioner procured the order in June 2022, the same came to be placed before the trial court in January 23. Thereafter, till date, 5 witnesses have already been examined. It cannot be said that prosecution is indifferent and has not proceeded with the trial. Learned counsel for state assures this court that remaining witnesses shall be examined within 6 months from next date fixed for recording evidence, subject to cooperation on behalf of the defense and systemic delays. Under such circumstances, and in light of the assurance given by the state, we are not inclined to grant bail at this stage. Trial court is requested to expedite the trial. Parties shall cooperate with the trial court in that regard.
Grateful.
Next.
My 3 years, 2 months, I'm in custody. My lord, the seizure was made from inside a courier office. My lord. The CCTV of that courier office was never seized. My lord, I was actually apprehended in connection with another case. Thereafter, I was tagged in this case. My lord. In that other case, Lordship was pleased to grant me bail. My lord, in this matter, my lord, the recovery of total 5.04 kilo of charas was shown from the possession of 2 people. My lord. But those 2 people were apprehended, bought. Thereafter, the statements were.
What is the stage of the proceedings?
2 out of 5, 2 prosecution witnesses have been recorded evidence of 2 prosecution
3
witnesses.
years they are already in custody. Already you give a report.
No, my
When
lord,
is the next date for
today was is date fixed for cross examination of another witness, and his chief has been completed.
Very good. When the schedule ends today,
My lord,
No,
only
no.
one date. My lord.
only one.
Only one. Today.
So let us do like this. We are keeping this matter 1 week hence. You give a report when your next date is fixed. All right. Petitioner is in custody for 3.5 years. He submits there is slow progress in trial. Learned lawyer for NCB submit. Today is fixed for cross-examination of prosecution witness. He seeks time to place on record report with regard to the status of the proceeding and with regard to the status of the case and a timeline to conclude the trial. Full stop. Matter will appear 1 week hence. It's only a bid because they are he is purchasing there and then through dark web he is getting it supplied directly to price of it. So it's almost like an aggregator. What aggregator? We give bail to one.
My lord, renewal prayer of bail, my lord, last rejected in October 2023. Petitioner is in.
For court to publish yesterday, I find that money trap.
The petitioner is in custody more than 5 years, my lord. Lastly, it was
My lord,
rejected.
kindly count to page 17, my lord. It was lastly rejected on 3/10/2023.
There
My lord, there was the
taken.
direction was preferably within 6 months from the date. My lord, the order has been communicated on 20th February 2024. My lord, August is the date.
Let me. My lord, the learned court did not take up the put up application because that's so date fixed. So we have to submit
We
that
are not-
order, my lord.
We are requesting you, please apply after the expiry of the time.
My lord, my lord, time will be expired on my lord. Yeah, if,
August. August.
then my lord, I am not pressing this
Not
application
pressed.
at this
Huh?
time.
Not pressed.
Because
Petition-
next date is fixed for me.
All
For
right,
evidence of the.
please wait till August and come. Not pressed.
এটা কবে হয়েছে রে রিপ্রেজেন্টটা কবে দিয়েছে তো এই তো দেখতে 275 bottles of fentanyl. We have received the FSL report in the month of uh, December 2023. We have filed the supplementary charge sheet, and out of 12, 4 has already been examined.
How long are you in custody?
1 year, 4 months, 11 days.
96 days I am custody man offense.
1 year, 4 months, 11 days.
Within what time frame do you propose to complete the trial?
But 4 has already been examined. Next date is on me.
All right. So
As per my instruction, 4 dates were fixed, no evidence were proceeded with. Next date is fixed on 5th May.
Date within my.
so within what period do you
296.
propose
My lord
to-
will kindly see
What is the quantity of narcotics?
275 bottles of
25 bottles
fentanyl.
of fentanyl.
So please, can you give us a timeline within which you will complete the trial?
My lord, 8টা বাকি আছে তো। Within no, within a year,
Within a year.
8টা 1 বছরে কেন হবে না? কি বলছিস?
You talk with the public prosecutor and give us a report. We are keeping it 1 week hence. Petitioner is in custody for 1 year and 4 months. He submits. No prosecution witnesses turned up on last 4 occasions.
3 dates, 3
On
occasions.
last 3 occasions, he prays for
3
bail.
dates.
Learned lawyer for state submits report.
95 is the
Contents.
next date.
4 witnesses have been examined. He is directed to submit further report with regard to a proposed timeline within which prosecution shall conclude the case. Matter will appear 1 week hence. Next.
Great.
And I am for the petitioner, my lord. Kindly see page 14, my lord. The co-accused already enlarged on bail on anticipatory bail, my lord. The petitioner is the same footing, my lord. And thereafter, the petitioner, my lord, pray for anticipatory bail that was rejected due to proclamation is issued. Thereafter, the petition proclamation is issued, my lord.
Proclamation was issued. So
Yes,
you are
ma'am.
absconded.
Yeah, thereafter, the petitioner was surrendered before the court, concerned court, my lord. And now he is
Anything is recovered from him?
no.
All right. Petitioner is in custody for how long?
54 days, my lord.
For 54 days, no narcotics was recovered. Investigation is complete. Co-accused has been granted anticipatory bail. Accordingly, prays for bail. Learned lawyer for the state opposed the bail prayer. We have considered the materials on record. Though petitioner had absconded for some time, we note no narcotics was recovered from his possession. His complicity has transpired from statement of co-accused before police officer, which are inadmissible in evidence. Under such circumstances, we are inclined to grant bail to the petitioner.
Good.
Next.
My lord, 20.
State, all the matters went there for transfer. On the other day, same thing happened.
My lord, here we are on bail and your lordship granted interim bail that has been extended.
18th April is the next day.
20, 22 and 24 are arising out of the same PS.
So all are on interim bail?
All are.
All are on interim bail, lord.
You are also on interim bail?
Yes, lord. All are on interim bail. Lordship, this is the report.
My lord, status report showing matter will appear on 18th April. My lord, kindly fix it in the first week of May so that we can come up with some kind of order.
30th of April, I think, the date was.
18th April needs Supreme Court.
Let us keep it on 15th of May or maybe after the summer vacation. You remain on bail. You are on bail.
I am on bail.
Bail is out within a time frame.
My lord, last time your lordship extended it till 30th April.
All right. Petitioner report is placed on behalf of CBI. From the report, it appears proceedings are stayed. From the report, it appears transfer petitions have been filed on behalf of CBI before the Honorable Apex Court and proceedings have been stayed. Petitioner is on interim bail. There is no adverse report. Full stop. There is no adverse report. Let these matters appear 1 week after the summer vacation. Further report with regard to the status of the proceeding we filed. Interim bail is extended till 30th of June or until further orders, whichever is held.
Lordship, file.
Are the report to the pendency of
বলেছে না পিটিশনার সাহস বলেছে
Well, report file may be kept with the record. So report file may be kept with the record. So, I'm 28 months. Well, it's really pitiable that NIA treats us like street dogs. Well, your lordship's specific instructions was that the protected witnesses 161 should be given to us. What they do, they give us a statement of protected witness who are not even witnesses in this case. Well, one by one, please let me finish. They are not witnesses in this case.
Don't
They are
get so angry. Don't get so angry. Mr. Mighty.
Why?
Mr. Mighty already is trembling. Don't be panicking.
Mother, 5 feet.
Don't panic.
May I submit one thing, Milord, subject to your lordship's
Mr. Mighty, he had.
Milord, Milord, now we are under tremendous pressure, but we have, Milord,
Why you
instructed
are
the
under
office,
tremendous
Milord,
pressure?
Milord, the instruction, Milord, we have given to the, Milord, investigating officer, Milord, to prepare the, Milord, that was a mistake, Milord, that was sent, Milord. In the morning, I have, Milord, been informed, Milord. Yes,
Mr.
Milord.
Banerjee is
Milord,
there.
in
He
course
is a
of this week,
competent
Milord,
junior.
yes, in course of this week, Milord,
What this week? We won by tomorrow. We are keeping this matter tomorrow. Tomorrow you must give.
by Wednesday, we'll do it.
has to be dated. They are
All right, by Wednesday.
Right.
I make a specific order
Yes,
that
sir.
by Wednesday and we
And
keep it on
kindly,
Monday.
Milord,
Right.
yes, Milord,
Right.
kindly fix up a date
And
for
we
the
record
next
our disapproval,
My lord.
Mr. Mighty.
my lord.
Uh,
And kindly, Milord, fix up a date in the next week, Milord.
Monday.
Monday বলে দিচ্ছে
Monday.
তো
Monday, অসুবিধা নেই।
আমাদের সুবিধাটা দেখো মাঝে মাঝে তোমার অসুবিধা দেখছো
Mr. Senior Counsel for Petitioner, submit in spite of direction given by this court, statements of protected witnesses had not been supplied. Learned counsel for NIA admits due to inadvertent error, other statements from a different case had been handed over.
By mistake.
Stop. We do not appreciate, we record our disapproval with regard to the casual approach taken in the matter. We direct the statements to be supplied to the petitioner positively by so and so. Day after tomorrow, Wednesday. Huh? Matter will come up for hearing on
Monday. Grateful.
charge.
Milord, only one thing may I submit, Milord. We have supplied the copy, Milord, accepting my learned friends, Milord, client, Milord. Nobody is accepting a copy. We cannot proceed with the, Milord.
That we will come when it
My
comes to merits.
My lord.
Let the statements
yes.
as directed by us be supplied.
My lord, my lord.
Then whether your progress is hindered by non-cooperation or not,
My
we
lord.
will see all those things.
My lord.
On last occasion, my lord, your lordship has directed to examine the victim girl, my lord, under section 311. Lord, I have seen the with the deposition. I will submit within a week.
So we keep it 1 week hence?
For this.
So 1 week, 1 week.
My lord.
On the prayer of the petitioner, adjourned for a week. Next.
Prayer for the petitioner. 302 subsequently 304. But the cause of death was due to drowning. Your last question, your lordship wants to know whether the visceral report has come or not.
Once FSL report has come, my lord, no poison could be traced.
All right. Petitioner submits that victim died due to accidental drowning. He is in custody for
1 year, 40 days.
more than a year. He prays for bail. Learned lawyer for the state opposes the bail application. We have considered the materials on record. Statements of witness, materials on record. PM report shows victim died due to drowning. Full stop. Whether the cause of death is homicidal or accidental requires to be assessed in the course of trial. Petitioner has made out an arguable defense during trial. He is in custody for a considerable period of time. There is no chance of abscondence. Accordingly, we are inclined to grant bail.
CGM
Next.
Howard. CGM Howard. CGM Howard.
Manual 31, I am for the petition.
Well, 31 and 33, let it be taken up together, it arises out of the same case diary.
Milord, on
I'll be
on
approved for
third Milord, all the matters Milord, relating to Milord that Subiresh Bhattacharya and other matters Milord, this Kuntal Ghosh Milord, is also same Milord.
But I am in RC6.
Yes, yes. Milord, all the matters Milord, connected matters Milord, would be Lordship's pleasure to take up this matter on third itself, so that Milord, there may be
You are
uniform.
saying that on third RC6 is also coming up?
Yes, yes, yes.
Then we keep it along with the others.
My lord, so
Three,
far my
five-
knowledge goes in RC6, only 2 accused persons have applied for bail.
No, that
And-
relates to.
And that is not fixed on
No,
third
no,
of
that I am praying for fixing the matter along with other matter RC3, RC5 and other matters. Milord. So
All
it
right,
is
on the
fixed,
prayer of CBI adjourned till Wednesday.
my lord.
My lord, they are directed to submit a report. If
Yes,
that
where is the
report is
report?
served on us, it would be convenient for us
It
to
will be
access.
served tomorrow.
By tomorrow, please,
Tomorrow.
report shall be served upon the petitioner,
My lord.
the counsels for the
My lord.
petitioners by tomorrow.
My lord.
দুটোতেই আমার সিদ্ধান্ত দুটোতেই 31 আর 33
31, 32.
33 টাও আছে আমি ওটাই বলে দিলাম
30. এটা কত আরসি কত তোমার
এটা এটা RC5
RC5 তো
এটা RC5
এটা
না 33 টা RC6
বলে দিলাম একসঙ্গেই বলে দিলাম
yes 32.
Man for the petitioner. My last occasion, your lordship direct the victim handed over to her mother and produce the victim and ready to hand over to her mother. Well, that matter.
Please.
The 376, 511, read with 8 and 12.
Victim has been
Praise the Lord. Lord, the petitioner is in custody for 2 years, 2.5 months. On the last occasion, your lordship has called for a report. While learned friend said the petitioner has criminal antecedents. There are 2 cases against the petitioner, this case and the other case. In the other case, Lord, he has been exonerated from the case. Lord, in fact, he has been filed as far as the petitioner is concerned.
My lord, regarding the criminal antecedent, my lord, in regard to the Durgapur PS case, my lord, he has been discharged. Initially, he was taken into custody and thereafter no materials found and he was discharged. And my lord, another case is pending before the Selimpur PS Patna under Section 27 Arms Act. In this
I am
matter,
on
my
bail.
lord, warrant is pending. This is the report.
the warrant
Give
is
me a
pending,
copy.
though, send him there. Send him there. Mr. Basu, with a production warrant, we are not going to give you bail.
No, that is all right, but that is all right. As far as this case is concerned,
No,
what-
this case you are in custody.
Huh.
How can we give you bail when a production warrant is pending against you?
let my learned friend give me a
Yes,
copy.
give
of
a
it.
copy.
Give me a copy. Keep it on
Petition-
Wednesday.
Copy of the report with regard to
No,
criminal
please.
antecedents handed over to the petitioner. Matter will appear on Thursday.
Thursday.
Because with production warrant,
that
it
is
will
all
be
right.
difficult
But I
for us to
understand.
give
I
bail
understand.
because it has to be executed.
Huh.
Why your trial is going on? The production warrant is there.
My lord, in this matter, my lord, on the last occasion, my lord, I submitted that 2 accused were involved in another
Convicted in that trial has come to an end.
That has
Now,
been completed.
now
Now
you start your trial.
my lord.
Only PW1 has been examined in
So
part.
what we can do, Mr. Basu, is you by Thursday,
My lord.
you talk with the public prosecutor
My lord.
as a time frame for finishing this trial so that he can be sent to Patna thereafter.
My lord.
37 witnesses, only one has been examined in
My
part.
lord, I will submit another report in this regard.
At least within 8 months to 1 year, you finish this trial. Because if he is to be tried in Patna again, you will have to send him to Patna.
My lord.
All right.
Keep you.
Thursday.
Yes.
My lord, I am for the petitioner. My lord, 326, 307 of the Indian Penal Code, 25, 27 of the Arms Act. My lord, there are 3 petitioners before your lordships. So far as petitioner number 3 is concerned, my lord, after being, my lord, arrested and when he was taken to the correctional home, my lord, he was subjected to tests and it was detected that he is suffering from HIV. I have placed that on record, my lord, but I don't have any documents. They have not supplied us any documents. Now, my lord,
is concerned, my lord. My lord, his CDI details showing that he was present in the place of occurrence, and there is a money trail. He has received money from a third person, my lord, for committing the crime.
He says that he is suffering from HIV.
my lord, let that report be called for by your lordships, my lord.
Petitioner content submits supplementary affidavit. and contents he is suffering from HIV.
Petition number 3.
Petition number 3. Report with regard to the health condition of the
You've got a
petitioner,
copy, no?
particularly with regard to HIV infection, be placed on record. Matter will appear 1 week hence.
One. I'm deep. Deep.
And what about 1 and 2?
My lord, 1 and 2, my lord, so
Recovery arms from them.
from bush, arms were recovered. There are 2 seasons.
Eyewitnesses not there.
Arms were recovered from bush.
There is no eyewitness, but
Now is the
CCTV
ballistic report is there.
footage report is there, my lord. It's matching
Matching what?
with the bullet recovered from the back of the head of the injured
My
person.
lord, we consider.
Moreover, my lord, there is CCTV footage confirming the presence of the accused persons in the spot, my lord. CCTV
See,
footage.
then which accused have been?
Both 1 and 2. They were
1
riding a
and,
bike.
1 and 2 gone.
Very well. My lord, Monday it is
All
come.
right. We'll,
I'm deep.
we'll reject 1 and 2
Right.
after considering whether
Yeah.
we will allow 3 for health reasons.
After
or
the
we
report
reject.
comes, my lord.
Yes.
I'm
let's
deep.
see.
Deep.
Lord, I am for the petition.
Lordship, I am for
My
the de
lord,
facto complainant.
altogether 4 persons they were sent up for trial. Out of 4, 3 are on bail. This petitioner, he is in custody for last 8.5 years. My lord, I am renewing my prayer for bail. On earlier occasion, on 5 occasions, my lord, my prayer for bail was rejected. Lastly, it was in the year 2022. My lord, there were several directions for expeditious trial. Now, out of 24, only 5 could be examined. All the orders, my lord, the Nalne trial court was privy to all the orders passed
All
by
right,
this
but
honorable
then
court.
it's a murder case. We are not inclined to grant you. How long you are in custody?
8 years, 5 months, 6
My lord,
months.
16 criminal cases are pending against this person, my lord. My lord, all are regarding Arms Act and NDPS Act.
My lord,
My
kindly
lord,
please when these
my
were
lord,
registered.
give us only 1 year time, my lord. We will conclude the trial, my lord. Within 1 year, my lord. I submit.
You give a report.
My lord, I will submit a report on the next.
Petitioner is in custody for 8 years. He submits only 5 out of
24.
24 witnesses have been examined. He prays for bail on the ground of delay in trial. Learned lawyer for state seeks time to submit report with regard to status of proceeding, criminal antecedents, and a timeline to conclude trial. Report be filed on the adjourned date, adjourned 1 week.
My lord, so far the criminal antecedent is concerned, my lord, let a report be filed because on the last occasion it was submitted by the state that he had 6. And now this is
That's why we want them come on record. You don't give a comprehensive report, sir, not in piecemeal.
My lord, deeply.
Grateful, Your Lordship. My lord, I am for the petitioner, my lord. My lord, allegation under section 498A, 304B, 306, 506 of the Indian Penal Code, Lordship. 498A, 304B, 306, 506 of the Indian Penal Code, Lordship. I am the husband. I am in custody for 8 months, 4 days, Lordship. Lordship, my wife was ill, Lordship. I was taken her to Calcutta Medical and College and Hospital, Lordship. Kindly come, Lordship, P2, page 11, Lordship. She was given treatment, Lordship, there, and she wanted to stay with her parents, Lordship. I took her to her parents' house, Lordship. After that, I returned. Lordship, subsequently, I informed that my wife died, Lordship. Lordship, I was present. I, along with my parents, Lordship, was present in the last walk of my wife life, Lordship. Wherein, Lordship, I have been assaulted by sharp-edged weapon, Lordship. A different criminal case has been initiated against them, Lordship. Lordship, I have annexed the FIR, Lordship. Lordship, wherefrom I was arrested by the police from my wife's parents' house, Lordship. And I was admitted hospital for 14 days, Lordship. All medical documents is lying in the jail custody, Lordship. Lordship, kindly see the medical report, Lordship.
Yes,
Lord, kindly see page.
cause of death.
Lord, poison. Lord, kindly 6 p.m. report at page 73.
She consumed poison.
She was administered poison so far as 164 statement.
How can she? She was kept at the parental home.
Biryani, my lord.
She was kept at the parental home.
Yes, she watched.
She was there at the
She was
matrimonial house.
She was taken by a auto with a saying that neighbor, I am going to hospital with him. Thereafter, she was left at the station and parents were informed that your daughter is lying at the station.
She was left at the station. That is the 161 statement of all the
Lordship, 161 statement, Lordship. And I reached my wife to my wife's parents' house, Lordship. Lordship, on the first day, on 26th, she was treated in Calcutta Medical College and Hospital, Lordship, when she was ill. And on the next date, Lordship, she was taken to Beldana Hospital by her parents.
Statement at page 60, the next door neighbor. 164 of the mother and the statement of the neighbor. At page 60. And the PM report.
At Beldana Hospital, her parents too.
Yes, yes.
Her parents
She was taken out from the matrimonial house. She was left at the station and was the parental relations were informed. The parental relations reached there. She was feeling. She was not feeling well. She was taken to the hospital. Page 60 and page 86 are the relevant statements, and the PM report suggests poison.
How can PM report suggest poison? Without FSL report, PM report.
That was evident, but the colonel sees poison. The PM report at page 73.
How PM report will suggest? PM report doctor understands poison, and the person who treated the victim doesn't understand poison. Brilliant. Page, let us see.
73. 73. Plus folding. You find it?
Lordship, there is a contradiction in the FIR. It was written that she was assaulted, Lordship. Some spot was in her body, Lordship, and the PM report is saying that no external injury was there, Lordship.
The day after dawn is fixed for framing of charge.
And for last 4 days, charge was deferred. I filed a revision for expedite the hearing.
All that we'll keep it on Thursday. Send back the case diary. Let the charge be. First, don't file bail applications before a substantial date hearing. We will take this very serious.
Lordship, then fixed it after if it is not framed on the next date, Lordship.
We want you to go and ensure that the charge is framed. If it is not framed, it will be a ground to reject your bail application, right?
No, Lordship.
So with that temperament, go to the trial court. That if I have to get bail, let the charge be framed.
Lordship.
Thursday.
No, I will be returning back the case.
Oh, definitely you will return and inform the public prosecutor that we want the charge to proceed. And we inform you, madam, these substantive dates, if you file a bail application, that itself will be a ground to reject your bail application. Next.
Next date.
Thursday. Next.
39, I am for the petition.
Come out, they found pungent. Yes, next.
376, 511, I have served copies. He refused to accept.
May I please, your Lordship? Allegation under section Foreigners Act, my lord, I am in custody for 350 days. I have annexed my voter card and passport.
All right. Petitioner has relied on voter's identity card and passport in support of his plea of citizenship. Let the matter appear 2 weeks hence. Report with regard to the authenticity of the documents we filed on that. Next.
My lord, I am for the petitioner, my lord. Section 6 of the POXO Act along with 376D, my lord, victim could not be served because
I'm for the petition.
Wednesday, Wednesday.
Petition. This is a bail jump matter, rejected 4 times and lastly rejected on 7th June 2023. The petitioner has been rearrested on 24th March 2017. Almost 7 years custody.
What did
identified in the TI parent earlier rejected by the Honorable Court of Appeal.
He is in custody for now almost
7 years.
now custody for 7 years. When will you?
Out of 34 witnesses, 24 have been examined. That is
You know, 7 years in custody. Petitioner is in.
the date of 9th is the next. 9th April.
All right, we'll keep it after 9th. Petitioner is in custody for 7 years.
Lordship, in the last order, in the last page, that is, there is a direction that it is for expeditious disposal.
Page.
Last page in the order.
Yes.
Order dated 7th June 2023.
When your last prayer was rejected?
7th June 2023.
7th June 23. 21. 22. 7 June 23. 1 year. So that period has not lapsed. Please come up after that. We have said 1 year in June 23. We are in April.
Lordship.
So that time frame has not lapsed. Petitioner is in custody for 7 years. He prays for bail. Learned lawyer for the state submit. Petitioner had absconded earlier. His bail prayer was rejected lastly in June 2023. 25 witnesses. How many witnesses have been? 24 witnesses have already been examined. We have considered the materials on record. Petitioner is alleged allegations against the prosecution case. The allegations against the petitioner are serious. He had absconded earlier. Prosecution has examined 24. His bail prayer was rejected on a number of times earlier. On June 2023, while rejecting his bail prayer, the trial court was directed to conclude the trial preferably within 1 year. The time frame has not expired as yet. Trial has considerably progressed. Hence, we are not inclined to entertain the application for bail.
I'm for the petitioner. 302. Allegation against me is at best 120B. I stand in a better footing than that of the person who has been granted bail by your lordship. That is at page 8.
Would I go? Petitioner is in custody, page
8.
Petitioner is in custody for
136 days.
138
days.
138 days. Co-accused has been enlarged on bail. Petitioner stands on the petitioner is in the factual in view of the extent of complicity of the petitioner in the crime, he is entitled to similar relief allowed. Next.
Make prisoners. Lord, I am appearing on behalf of the accused petitioner, one of the accused. My Lord, the case is under section 302-201 and read with section 6 of the POX Act. Lord,
18 days, Lord, victim have been served, Lord, there is a love affair between the parties. She has accepted in the 160 evidence as well as in the 164. Lord, I've annexed the affidavit. Your Lordship has recorded.
She has been examined.
Yes, yes.
We have considered the materials on record. Vulnerable witness has been examined. Petitioner is in custody for
1 year, 5
we
months.
have considered the petitioner is in custody for 1 year and 5 months, over 1 year and 5 months. Vulnerable witness has been examined in view of the aforesaid development and the period of detention suffered by the petitioner. We are inclined to grant bail.
Obliged, Lord. Satisfaction. Lord.
Victim was examined, my lord, before the rejection of your lord.
Oh, before the rejection.
Thereafter, Lord, 1 year, Lord, no witness has been examined.
Then you give a report.
Yes, Lord.
Hmm.
I've annexed the certified.
Petitioner is in custody for 1 year and 5 months.
Depositions clear.
They are when was the vulnerable witness examined?
My lord, they were examined March. I've annexed the, my lord, certified copy. 31st March 2023.
17/7/2023.
Nah, March.
Petitioner is in custody for over 1 year, 5 months. He renews his bail prayer. State shall submit report with regard to the status of the proceeding on the agenda. Next.
Sure.
1 week.
1 week. Obliged.
My lord, the petitioner was 20 and the girl was 13. Now this petitioner is in custody for 5 years, 5 months. My lord, there are altogether 10 witnesses. They were examined. The date was fixed for 313. On that day, my lord, by invoking section 319, the court directed another person, Bappa, to join the trial. My lord, he surrendered. He was taken into custody. Subsequently, my lord, he was granted bail. Now, from April, my lord, the trial will commence so far Bappa is concerned. My lord, I have the evidence of the PW1.
Why Bappa was active? What was that?
Can I report?
Petitioner is in custody for more than 5 years. He prays for bail.
Report.
He shall submit report with regard to status of proceeding and reason for delay. The accuser is included. So Bappa has also raped the girl.
No, Bappa took my lord, the allegation is that he videographed the entire incident. Now, my lord, so far the evidence of doctor is concerned, my lord, there is no evidence of violation. Even the
that is all right. All right. Adjourn 2 weeks.
And victim said that IO told her not to disclose the name of Bappa initially. Victim, that is her that is her evidence.
But is the videography on record?
Nothing. Nothing was this.
All.
Him to supply the depositions.
There is Xerox question with the
Number 48. 48, I am for the petitioner, my lord. My lord, 48, I beg to appear for the opposite party number 2, the victim. The petitioner is now in custody for 1 year, 11 months. The
Is there any evidence
My lord, for the petitioner, my lord, affidavit of service, my lord.
I've just received the CD, my lord. It is very important. Please address it.
Wednesday.
Wednesday.
Victim has been notified.
Yes, my lord. I have served, my lord, but it has not been served, my lord.
You have served, but it has not been served.
No, my lord. I have served, but he has
Officer in charge,
address
Joymalya Police Station shall notify the victim with regard to the proceeding, pendency of the proceeding and next date of hearing adjourned 2 weeks.
Wednesday. Madam, for the petitioner, my lord, 300 to 34. My lord, as per FIR, one Biplab Sarkar is the principal assailant. He hit the deceased with a Bhojali, resulting his death.
And you hit him with what?
109 days in custody.
You hit him with what?
I don't. There is nothing against specific against this petitioner in the.
All of them attacked him.
My lord,
Kindly see the FIR.
for the doctor, my lord, the name of the petitioner has been mentioned as assailant. My lord, 164 to page 90.
Yes, but then patient was unconscious. How the patient
party my lord stated.
the patient party stated? Let us see the eyewitness.
164, page 91.
90.
My lord, the petitioner caught the deceased and Biplab assaulted the deceased by knife. 164.
All right. Petitioner submits that how long you are in custody?
190. 109.
Nothing. Huh? Don't press the application now. Come after at least 6 months. Not pressed.
I am for the petitioner. My case under 498 and 302. I have been in custody for 2 years, 3 months. Charge sheet has already been filed. Case has not yet been charge has not yet been framed. Interesting part is that the day of occurrence at around at the evening 7:05 p.m. this complaint was lodged by the victim brother of the victim girl. The victim is the wife of the petitioner.
You fired at his wife. Then
Now, my car has been seized from police compound of Rajapur police station that shows from the seizure list, no mentioning in the charge sheet. But UDK started at the time of I brought my wife to the hospital. That was not recorded. I couldn't find that Now, under UD case of Uluberia, postmortem conducted. Most interesting thing that when I was arrested from Rajapur police compound at around 7:55 p.m. Now 7:05 p.m. this was registered, and forensic team they were present from Belghoria at 7:55.
you have considered the materials on record. Petitioner is the husband of the victim lady. He had fired at her, resulting in her death. PM report corroborates a case of homicidal death due to gunshot injuries. Ballistic report. In view of the aforesaid materials, incriminating materials on record and gravity of the offense, we are not inclined to grant bail. Next.
Malar 399, 402, 14 Foreigners Act, 7 years, 6 months I am in custody.
Yes.
Out of 16 witnesses, only 1 witness have been examined.
You are a foreigner, no?
Foreigners, but the highest punishment your lordship knows very well, 8 years. 7 years, 7 months. 7 years, 7 months.
Out of eight persons, 7 has been enlarged on bail. Kindly sees the conduct. They are not coming to court, they are absconding.
Now on last date, 4 persons have come, my
The
lord.
next date is on 18/6/2024 for execution of warrant of arrest. All the persons who has
who have been enlarged on bail as absconding.
You are a foreigner, how can we give?
But 8 years punishment, 7 years, 7 months I am in custody. But more so, on earlier occasion it is revealed from the order sheet that out of 8%, 4% have present, are present. my lord.
Petitioner is in custody for more than 7 years. He prays for bail. Learned lawyer for the state submit delays due to abscondence of co-accused who are on bail. We have considered the materials on record. Petitioner is a foreign national. Delay is due to abscondence of co-accused who are on bail. Under such circumstances, we are not inclined to grant.
My lord, 8 years my lord, will be passed, my lord, in the
Shall
meantime.
be expedited.
But
Require 8 years.
presiding officer is not there, my lord.
You remain for 8 years.
I love it.
My lord, this petitioner, he is in custody for 938 days. My lord, he is not FIR named. My lord, may I take your lordship only to the order dated 24th January, annexure P3, page 18, and the order in page 20. My lord, 2 persons, they are granted bail by this honorable court. My lord, out of 62 witnesses in page 20, my lord, my instruction is only 19, they are examined. And my lord, this petition is standing on the same footing with this Mukhtar Hossain. I have the deposition of PW1.
The petitioner
My
is
lord,
also
who is-
standing on similar footing of those persons who are on bail.
My lord, he was also standing there. No overact is there. My lord, I have the deposition of PW1.
Your statement and also the eyewitness statement, petitioner Hon'ble.
Halt who?
Yes, my lord. Kindly see, my lord.
That witness has been examined.
Yes. My lord, the Sahalam Sarkar PW1, he was one of the eyewitness. Yes, my lord.
Who is the eyewitness who said that petitioner had hurled bomb?
My lord, Shoel Rana, injured witness.
Shoel
Rana.
Shoel Rana has been examined. Okay. Wait for Shoel Rana.
No, Shoel Rana is not examined.
Because
Now, my lord, considering PW1, my lord, kindly sees the
others were not implicated by Shoel Rana. Petitioner submits that he is in custody for over 900
My lord,
days.
may I come back tomorrow only? May I just see the Shoel Rana?
Not today.
It would deposition take together. It would deposition together.
আমাকে একটু দিও তো কে কে এক্সামিন হয়েছে আপনার?
Give a copy of the deposition to Ms. Das.
What is your score? Shoel Rana examine.
Yes. In spite of communication, appeal is defective. Department communicated. Department intimated the learned advocate of the appellant to remove the defects. No steps have been taken. No steps have been taken. Learned advocate, appellant is directed to remove defects at the earliest. Let the matter go out of list. Liberty to mention. Next.
Oh.
Item number 55.
My lord, I am for the respondents.
But section 5 is there, my lord. There was a delay of 87 days. Liberty be given to correct the prayer portion, my lord. It has been wrongly written as 73 days. It will be 87 days.
All right.
My lord,
Liberty to correct the prayer portion of the petition.
my lord, regarding delay, my lord, my submission is simply stated that this has not been properly, my lord, explained. As a lordship, please. As a lordship, please.
Affidavit in opposition to the application for condonation of delay be filed, adjourned 2 weeks.
And my liberty to correct the. Very good.
There is a delay of 70 days.
Your lordship, direction, my lord, victim girl also notified, but it was returned. My lord, no one is residing with this place.
No, have you served the copy?
Yes, my lord, this
But-
is the affidavit. It's
but
a
not-
legal
not
matter,
the
my lord.
property, it returned.
It has returned.
রিটার্ন ওই খামটা দাও সাহেবকে
ওই খামটা তুলে দাও তাহলে। হ্যাঁ,
এটা খুলতে হবে না
খুলতে হবে না। এটা দিয়ে দাও, বুঝে যাবে, এন্ডোর্সমেন্ট।
টেন্ডারের কাছেই ফেরত এস ইচ্ছে করে ফেলেছি
What is the endorsement?
ওই যে খামে
My lord, in the
consignment
consignment.
in the consignment
আরে ওখানে ওপরেই লেখা আছে, খুলতে হবে না, ওপরেই লেখা, ওপরেই লেখা।
You please serve afresh.
My lord,
That's the same, my lord.
through police, my lord, it will be served, it will be better.
All right. Copy of the application be served upon opposite party number 2. Upon opposite party number 2 through the officer in charge. Same police station they reside.
Yes, yes.
Bongajal Ghati police
Yes.
station. Report be filed on the adjourned date, adjourned 4 weeks.
Both are never.
Next.
কবে ডেটটা জেনে না?
আমি একটা কপি দিয়ে দেবো তো
কপি দিয়ে দিই।
My lord, I am appearing, yes, my lord, I am appearing for the appellant, my lord, this is also legal aid matter. My lord, there is a section 5, there is a delay of 173 days in filing of the application. My lord, section 302, life
Where,
imprisonment.
where is the section 5 is there?
173 days delay, my lord.
Or like delay, abatements, delay condom, liberty to admitted, issue usual notices, liberty to pay for suspension or call for records, liberty to pay for suspension of notice. Next.
for that
Service upon the victim girl is not complete. In case of section 5 application,
All
41
right,
days.
copy of the application be served upon opposite party number 2 through registered speed post with acknowledgement due. Matter will appear 4 weeks hence.
I beg to appear before the petitioner, my lord. My lord, we have served upon the state, my lord, but the victim deceased, my lord.
Huh?
It's under section 376D, my lord. There
The rape victim guy's father is not a victim.
My lord, my lord. Admission of applicant.
Admitted, issue usual notices, call for records, liberty to pay for bail upon notice to the state. Next.
Your Lordship, I'm praying for the admission of appeal under section 364, 300 to 200.
In time inform?
24/1/2000.
Oh yeah, same order. Yes, next matters. Yes, the case. Anything remains in this case.
My lord, already with the leave of my lord.
Charge sheet has been filed.
Charge sheet file witness action is going on. In the first case,
All right.
1450.
Learned lawyer for NIA submits. Charge sheet has been, state of West Bengal had assailed the transfer of the case to NIA. However, learned lawyer for NIA submits. Charge sheet has been filed
and
trial is already in progress. In view of the aforesaid development, we are of the opinion nothing survives in the application. Application is disposed of, is accordingly disposed of.
Would maybe take with the record.
The report is kept on record. Next.
62 and 63, both.
Yes.
Both same. Deeply obliged.
My lord, that matter, my lord. Everything is complied, my lord's order, my lord.
Nothing is complied. He will say nothing is complied. He will say everything is complied.
Sir,
Last officer, my lord, I filed the affidavit of compliance, my lord, and copy has been served on the petition. Yes.
Affidavit in compliance, compliance report টা পেয়েছেন?
Page.
So caller আছে।
SDO এখানে admitted that they divided the field on two parts. And road they constructed in between the field that they accepted. And they also misleaded that no road is there outside the periphery. But there is outside the periphery, the road is there. But even then they construct a new road by departure from your direction. It is a very and one Mr. Lakshman Prerulan, the ADM, Poschim Mednapur, he also accepted and submitted a map showing that the road outside of the deck.
My lord, only, my lord, behind this, my lord, grounds, my lord, only one narrow road, my lord.
Now, why will you keep the road? Why will you file an application showing where are the violations contrary from the report and pray for appropriate orders against the SDO? Who constructed this road? Why you have kept this road open?
No, my lord, finally, my lord.
If it is in the middle of the park, you should close the road.
Yes. No part of land is used for a road. Clear direction on 17/7.
Then
no part is being used as a road, even after they constructed the road.
Oh, my lord, kindly, page number 19, my lord. Kindly, my lord. Have a look, our, my lord, not middle, my lord. This is the back of this, my lord, grounds, my lord. Not kindly, my lord, our map, my lord, I have filed, my lord. This is the, my lord, playground. My lord, this is the approach road, my lord. Behind this, my lord, page number 19 of our report, my lord.
So in their map,
19.
My officer is not very efficient. Please help him.
আমাদের
May I submit, my lord? My lord, I can assist you, Lordship. Thing is that, my lord, there was one existing narrow pathway on the western side of the playground, very narrow road. Only some moram have been spread over there, and that particular narrow pathway is is there for years together, my lord, to access the main road. My lord, the village is
What is the
situated.
proportion of this pathway in respect of the entire playground?
Entire the big one. My lord, I have demonstrated everything in paragraph number 7 and 9 of
Page
my
number,
affidavit.
my lord, page number 19. Kindly, my lord.
Yes.
I will do, my lord, page number 19. Everything is clear, my lord.
Now, what is B? Proposed road?
My lord.
This is two part.
What is B? That B, proposed road?
B is constructed road.
Then when did you construct it?
C is within the field, within the land.
No, C is the playground.
C is the playground. A is also include the they divided to B.
So A is also a part of the playground.
Yes.
My lord, this is the ground of this playground, my lord. It is a part of the playground.
Now then why did you construct this road?
This is the
My lord, I'll demonstrate, my lord. Thing is that, my lord, you knows, my lord, I hail from Midnapur. I know the real fact, my lord. My lord, this is the playground, my lord. This is the existing road. At this particular portion, my lord, previously your lordship will recollect that some cow sheds were there.
That we got
Your
removed.
lordship's order, my lord, cow sheds have been demolished. Everything encroachment has been removed. Only this small area, this area has been kept for children's park.
No, no.
My lord, this road was existing road. My lord, is existing one and is very narrow. And this is the playground. Previously,
Yes,
road
but
was-
this
road was filled
even
to
if
middle
you
of-
have a road, this road cannot have any fencing.
Pardon,
This road cannot have any fencing.
my lord, we have fenced the entire playground.
But not the road.
No, previously, my lord, confusion has been created by the petitioner, my lord. Thing is that
No,
previously road was
petitioner has not created a confusion.
Sir, রাস্তা নতুন করে তৈরি করেছে 30 feet wide, not a small.
You
এবং তার
want what
মাঝখান
is the
দিয়ে ঘিরে করেছে।
what is
যেখানে আরবান রোড 20 feet, এখানে 30 feet wide road তৈরি করেছে।
why
Like a
May I
national
submit,
highway.
my lord, may I submit? Well, previously road was across the middle of this playground. That has been removed, my lord. And entire playground has been, my lord, fenced by the precast.
has A been fenced?
Not yet, my lord.
Then
It has been kept for children's
your purpose is to separate A and again allow illegal encroachers into it.
This small area has
We
been
have no
recovered.
problem. Listen, if for villagers you require road B, very good. But A also has to be fenced.
Okay, my lord. Okay.
My lord.
A has to be fenced and A must also be maintained as a playground.
Sir, road is outside periphery is there. Again, new road এই যে জায়গাটা এটা এনক্রোচ আপনার ডাইরেকশনে এই জায়গাটা আমরা এনক্রোচ ফ্রি করেছি সেই ওই যে কাউসেট এসব ভাঙাভাঙির পরে এটা তৈরি করা হয়েছে কালেকশন করা হয়েছে মানে রিকভার করা হয়েছে
এইবার কাউশেডটা যখন এনক্রোচমেন্ট রিমুভ হয়েছে এবারে চারিদিকে একটা ফেন্সিং করে দিক ঠিক আছে এবার ওই রাস্তাটার ব্যাপারে উই রিকোয়ার স্পেসিফিকেশনস when this road was constructed
24 আপনার আপনার
if this road was constructed after our order is passed
হ্যাঁ
then we will haul up your officer for contempt
ওরা নভেম্বর মাসে
why you will construct the road without our leave
17/7 স্যার আপনার অর্ডার আর ওরা 11 নভেম্বর মাসে ওরা রাস্তাটা তৈরি করেছে deliberately they departure from your order.
My lord, page number we have clarified, my lord, page number 4, my lord, paragraph 7, my lord. Para 7. Para 7 and 8, my lord.
So if someone opposes, you alter a court order in a meeting. What is paragraph 8 and 9? A meeting is held in the municipality and
SDO IC Kotwali.
one second. And as per the decision, has completed fencing and closed the pathway which was the middle of the playground. So and so.
Para 11.
What women and children park? A is women and children park. Now, how B comes into being is not clear from the report.
No, Malad, page number, Malad, para 11. Malad.
Read it. Please read it. Let us
Not
see.
at present, inhabitant of the local area, including school students, are using the newly constructed pathway.
So when the pathway gets constructed, we understand newly constructed. When do you construct the pathway?
My lord, if you takes trouble to go through the my affidavit, my lord, page number 5, paragraph number 9. আমার এফিডেভিটটা হচ্ছে আগের দিন জমা পড়েছে।
স্কুলের ছাত্রদের যাওয়ার জন্য আউটসাইড দিয়ে বড় রাস্তা আছে, পাবলিক যা ব্যবহার করছে সেটা, কিন্তু এখানে নতুন ভাবে একটা জিনিসকে উত্থাপন করছেন এবং ওনাকে এস্টাবলিশ করতে চাইছেন যে এই রাস্তাটা দরকার, কিন্তু ওই রাস্তার কোনো দরকার নেই যেহেতু চারপাশ দিয়ে রাস্তা আছে।
এই প্যারাগ্রাফ নাম্বার 9টা দেখাও, এটাতে পুরো ডিটেইলস বলা আছে।
This is yours. I think this is yours. Yours. Yes, where is your affidavit? What do you say?
affidavit হলো প্যারাগ্রাফ নাম্বার 9। নেই, খুঁজে পাবেন নেই। ফাইল ছিঁড়ে যাবে।
Now, your statement runs contrary to the statement of this SDO.
Same
Para 12. Para 12, my lord. Our report, my lord, paragraph 12.
Yes, paragraph 12 is completely different. And proposed pathway. He's saying a proposed pathway, and you're saying that there is already a pathway. You see the affidavit, it says that there is a pathway. Now, when did you build the pathway? When the pathway was developed? Let us get a clear picture.
নভেম্বর মাসে স্যার এই রাস্তাটা তৈরি করেছে 17/7 আপনার ক্লিয়ার ডাইরেকশন, তারপরে ওরা স্যার এটা করেছে deliberately the departure from your class.
Programs have been spread on 20th 11 2023, paragraph number 7, my lord, of my affidavit.
So why, if that is so, we will direct that pathway to be removed.
Title suit, no, my lord, my affidavit, my lord, affidavit filed by municipality, my lord.
Yes, we are seeing.
Paragraph number 7.
Yes.
There is no title suit, my lord.
What title?
দেখুন আমাদেরটা দিন, আমাদের না অন্য সেটের সাথে আমার ভুলেই যাচ্ছে বুঝতে পারছো না
So we said there should not be a pathway through the field. Now you have allowed a pathway that is proposed B, dividing the field into plot A and plot B.
Yes.
How can you do that?
Plot A, my lord, that has been required pursuant to your lordship's order, my lord.
That is a part of the field?
That is
Yes
true.
or no?
Very small one.
Yes, small,
That has been
big.
that has been kept for children's park, my lord.
That is your decision. Children's park, for that you do not require a pathway. Children,
Pathway.
you can keep entire field for children's park.
Yes.
But how do you prepare a pathway when we have specifically stated that no pathway
Paragraph
shall...
number 9, my lord. Line full onwards. A narrow pathway on the western side of the said playground, as was using years together by the local people.
So let
the same was only developed by
listen,
spraying Moram.
if they used a field by walking through the field, nobody can stop them. But why will you make it a pathway?
Yes.
Don't make it a pathway. A person can have a right of user walking through a field. That is an easement right over a field. That does not make it a pathway. You cannot change a field into a pathway just because people are walking over the field.
এটাই স্যার আমাদের বক্তব্য
This is not done. We direct that the pathway be removed.
Yes.
Pathway has to be removed.
And tree also planted inside the field. That also shifted outside the.
Whatever is planted inside the field, you go and plant 5 more trees inside the field. But the thing is, no part of the playground shall be converted into a pathway. Now, if people are walking through the field, they can walk through the field.
But entire ground has been fenced.
So let it be fenced. Let it be fenced.
That small portion.
Let it be fenced. Let there be a gate where people can walk through the field, but there cannot be a pathway in the field. The field cannot be broken into plot A and plot B.
This is the sir.
There should be a complete field, which is A plus B. Correct? In A or at one end, you can have a gate which can be used by people to walk through the field as a part of their easement rights, if they have any right. But you don't convert the field into a pathway. You know, under the municipality, under the laws, your Bengal Municipality Act, preparing a pathway is a change of character, change of use of the land. How can you do that? How can you do that? A person can walk through a field as a right because if he does not have any access, he has other access. Our question is, even if they have other access, if for convenience,
yes, together.
Other access is there.
If they walk through the field, they can walk through the field, and that you can have a gate which will be kept open if emergency arises. But the field will be used as a field, not as a pathway. How your SDO permitted, sir, the conversion of the field as a pathway? This is not right. My order dated 17 July 2023. This court directed the entire playground to be fenced. In the said order, it was categorically stated no part of the playground shall be converted into a pathway. Full stop. Compliance reports have been filed by the subdivisional magistrate and subdivisional officer, Midnapur Sodor,
Respondent number 4, my lord.
Respondent number 4 herein, as well as the chairman of Midnapur municipality, respondent number.
He is not in the contempt application.
He is not chairman municipality, full stop. In the compliance report filed by the state, it appears a portion of the land, a park, has been barricaded and marked as A in the sketch map and a B in the sketch map annex 2. Remainder of the playground marked as A has not been barricaded. It is proposed to be used as a women and children's park. Most strangely, a proposed pathway marked as B. Most strangely, a pathway has been proposed and marked as B in the sketch map. The pathway, learned petitioner appearing petitioner in person contends that the pathway has already been constructed in violation of our order dated, in violation of our earlier order. Affidavit of the chairman municipality, affidavit of the chairman municipality states on 2011-2023, a narrow road was constructed through the playground.
Developed, my lord. In the affidavit, it is developed, not constructed, my lord.
All right. A narrow road was made by spraying moram. As per the demands of the by spreading moram. Learned councils for SDO and municipality contents, there was a demand for local people had made demand for a road.
My lord, kindly have a look, page number 14, my lord. Inspection report by the executive magistrate, Paschim Midnapur, my lord, page number 14. In our
Yes.
affidavit, page number 14.
Huh.
Lord, kindly record.
Huh. Yes, what is there? Even Learned Council for SDO referred to the inspection report and stated there was public resistance who wanted to who opposed the fencing on the ground and who opposed the fencing and insisted that a passage on the ground that their movement through on the ground that the passage would be closed, that the passage through the playground would be closed and their movement shall be greatly hampered. Full stop. Mere user of local people আচ্ছা কেটে দিয়ে বলো there is no dispute that the plot in question is a plot in question there is no dispute that the plot in question is a playground. Full stop. No records of the municipality do not show any road running through the playground. Under such circumstances, this
BLLRO, my lord. Records maintained by the block.
BLLRO do not show any road or pathway running through the playground. In view of the aforesaid, this court directed this court by order dated 13/7/2023 directed
17th July
that no part of the playground shall be used as a road. However, now in spite of such injunction, presumably due to presumably on local protest, on 20/11/2023, a pathway was made by laying moram through a portion of the road, to a portion of the playground. Full stop. This amounts to an illegal conversion of the playground into a pathway, which is impermissible in law, which is impermissible. Accordingly, we direct as follows, comma. Pathway 1, pathway prepared by laying moram shall be forthwith removed and the same be converted forthwith change of user of the playground by preparing a pathway marked as B in the sketch map annexed to the affidavit of SDO be removed and the playground restored. Remainder of the playground marked as A shall be fenced. A gate a gate may be made at a end of in the fencing so that local inhabitants may traverse the field. Now, it is strongly contended that local residents have been traversing the playground on foot for convenience. In order to ensure no inconvenience is caused on one hand, and the playground and the character of the playground is maintained on the other hand, we direct a gate be created at one of the ends at one of the ends of gates be created at the ends of the playground through which local people may traverse by foot no other no vehicle etc shall be allowed inside the pathway. Steps shall be taken that the playground is that such user shall not damage or degrade the character of the playground in any manner.
Sorry for interference, my lord. Your lordship has said, my lord, one gate instead of one gate, my lord, in the north side and
Gates shall be made. They will walk through the playground, but no carriageway or vehicle will be used, and this user shall not change the character of the playground. We do not wish to inconvenience people who are walking. It is possible they will go through the playground, but this is not right. We want this to be done. If this is not done, sir, we will haul up your officer for contempt. We are being very lenient.
single fence, sir. Single fence, একটাই যেন বাউন্ডারি হচ্ছে চারদিকে আর ফাঁক
The entire playground, we have said that the remainder of the playground shall be fenced and 2 gates shall be created for movement by feet of the
users.
User. Right of user will be there.
Users.
North, south, east, west, your chairman will decide.
Sir, the permanent fund for permanent boundary wall is needed. Last 3 or 4 years.
Let us see. At least with our pressure, some boundary wall has come up. Then we will see permanent impermanent. This is not the way you treat the court's order. We understand there was local pressure. If there was local pressure, you should.
Local pressure created by a chairman. Local pressure is a natok. What is natok? What is created by a chairman and
chairman are popular people. So naturally, they have power to create local pressure for various reasons. We cannot comment on that. But what we want to do is the law will prevail above all pressures. All right? That we will ensure.
So please or direction to the district magistrate for the fund for permanent boundary wall.
We will do it later on. Everything cannot be done now. Permanent fund. Other matters 2 p.m.
Gate put.
Get.
ঠিক আছে ওটা তো তো হচ্ছে 30-40.
আরে আমার কাছে ব্রিফ নিয়ে নিচ্ছে
আমি আমার কাছে আছে
ও আচ্ছা
তুই কথা কি বলবো
বলে দিচ্ছি আমার if I've prayed for relaxation of a condition because my lord, I am in custody in connection with another case. My lord, I got bail. There was a condition to meet the investigation officer once in a week. Well, that is the thing.
My lord, Miss Monisha Sharma was appearing for the state. She instructed me that your lordship intended a report to be brought before your lordship to show that whether he was in custody from which date to which date.
Not to till date, I'm custody.
Oh, my lord, if I can be given 2 days, my lord.
Next week. Come on.
Highly urged.
আরে আমাকে ব্রিফটা দিতে
Briefটা ওই সব
তো সব ভাগ গয়া
65.
Then, my lord, the state has challenged an order of bail on the ground of perversity. The affidavit has been relied on. The affidavit purportedly has been filed by the victim, stating that she didn't have any grudge. So, my lord, that affidavit has been relied on, and the bail has been granted to the. I have already
That
served.
is Mr. Arindam Jana.
My lord, I have already served.
I'm for the opposite party, lordship.
Where is the affidavit? Where is
Lordship,
the
I'm praying for some more time to file the affidavit in opposition. Kindly grants me some more time.
affidavit in opposition be filed positively within 4 weeks?
I'm highly opposed.
Reply if any 1 week
Highly
thereafter, matter will appear 6 weeks hence.
Highly.
Ninth April, my lord.
Very bad. You are the only person.
Is fixed for evidence of the investigating officer, my lord.
So about to end.
Yes, my
All
lord.
right. Petitioner submit that trial is at its fag end. Date has been fixed for examination of the investigating officer on 9th of April. Let this matter appear in the monthly list of May 2024. Report with regard to the status of the proceeding we filed on the adjourned date. Next.
ফাইনালি করুন না সামনেটা রাখছি তুমি মাঝে
junior. And for some of her personal difficulties, she had been to Pune. Actually, her brother has faced a massive accident. That's why she was unable to present herself before your lordship. And it has been informed to me today morning itself.
So tell us
Lordship,
when should we fix the matter for hearing?
it can be fixed, lordship.
Today it is fixed. That's
Lordship,
why-
opposition was supposed to be given. Opposition has already been given by this time.
So begin the hearing. Let us start the hearing.
If my lord wills to proceed, I can. Actually, I'm not with the brief, though, lordship.
We are saying is then tell us when you will be ready. We'll fix that on that day.
Any date, lordship. After 10 days, any day. Actually, she is returning on 10th of this month.
Very good. Adjourned 2 weeks
Grateful, lordship.
on the prayer of
And
opposite
may I
party.
request one thing as a matter of last chance, because
As a last-
15 times Malad adjournment was.
Yes, that is our last chance.
Grateful, lordship.
Thing is flamboyant.
আমি অপোজিট পার্টি আর কি আর কি ক্যান্সেল হবে 4 সপ্তাহ একজন ভর্তি হয়েছে আমি ওর একটা বিল হবে 4 জন ভর্তি চাইয়ে
জীবন নাই তো
Lordship, item. Lordship, I'm,
for the opposite party.
Yes, then
Lordship, I'm for the petitioner, Lordship. Lordship, 69 to 74, Lordship, all analogous matters, Lordship, cancellation application, Lordship. Lordship, I had called for a report on the last occasion, Lordship. On the last 2 occasions, your Lordship had directed for report.
you are the complainant. Tell us what is the stage.
Lordship, they are not appearing before the court below, Lordship, because of which
You are appearing, lordship.
We'll cancel your bail, Mr.
No, lordship.
Lordship, on 29th of 9, 2023, Lordship had directed, Lordship.
Well, we are appearing. I can bring the order. কি আছে রিপোর্টটা দেন একটা রিপোর্ট দিলে 2021 last 3 years. One of the accused person is not absconding. The split একজনকে পাওয়া যাচ্ছে না নাকি আগে ধরে কত 3400
Lordship, till date, that proclamation has not been given, Lordship.
You are Mansoor Ali, opposite party?
or yes, lordship. I am all in 5 matters, lordship. There are 33%, lordship. One person is not arrested. He is absconding, lordship.
Lordship, there are total 43 accused persons.
Imtiaz Ali.
41.
This 49, but how many opposite parties are there?
Lordship, in total, there are 41 accused persons, Lordship.
Correct. So you have filed cancellation separately
Lordship.
for each.
Yes, Lordship. Not all separately, Lordship. In some of the applications, there are 5, there are 7.
The allegation is against one Mansoor who has misused liberty.
Lordship, my cancellation is against all the accused persons, Lordship.
Split up the trial and lordship we can appear before the court, lordship, regularly.
Basically, to give direct.
Once again, report is placed on record. Copy of the report be handed over to learned counsel for the petitioner as well as the opposite party. Matter will appear 4 weeks hence. Go through the report. Misuse, allegation of misuse is against Mansoor only.
Yes, please. You put a copy.
The copy day.
কপিটা এখানে নিয়ে নিন। এখানে নিয়ে নেবো, তাহলে কপি দেবে না।
$75.
My lord, 75 and 76 arise out of the same matter, my lord. On the earlier occasion, lordship was pleased to direct the state to file a report about the conduct. My lord, the details are there, but the report is not in correct form. My lord, out of 4 accused persons, my lord, 2 are regularly attending court. My lord, that is, my lord, accused Hon'ble Sheikh and Ataur Rahman. They are attending. But my lord, so far as Mohammed Fakir Ahmed and Mohammed Ziaur Rahman is concerned, my lord, they are absent since 25th of May.
Who is representing Ziaur?
I am item number 75, your lordship, opposite party number 2, Atiur Rahman, your lordships. And item number 76, your lordships, Amirul Sheikh.
And Fakir and Ziaur? We have made ourselves clear that if they do not appear, the trial court would be at liberty to take appropriate steps.
Next date is on 15th of May for execution report of their my lord, proclamation and all, everything has been.
So bail has already been cancelled. Bail has already been cancelled of these 2 persons. Then how can there be execution report?
Not yet, my lord.
How can there be an
My
execution?
lord, warrant of arrest was issued, my lord, on 8th of
Against
April
whom
20.
or warrant was issued?
My lord, Fakir Ahmed, alias Fakhruddin,
Huh.
my lord Ziaur. So far as
I'm
Amirul and Atiur Rahman are concerned, they are regularly
So
appearing.
you are asking for cancellation for whom?
My lord, in respect of Mohammed Ziaur Rahman, alias Zaidur, and my lord Mohammed Fakir Ahmed, alias Fakiruddin.
The bail has already been cancelled. That is why warrant has been issued.
But my lord, since that is the difficulty, my lord, lordship on the earlier occasion was pleased to direct to file a report. The report is not in correct form. That is why we are unable to furnish all the details. I had directed.
No, so the question is, if their bail has been cancelled, then we dispose of the application. So for
Kindly allows a week's time, my lord. Let me come up with all the details and the order
Okay.
sheet thereafter, lordship.
adjourn for a week.
I'm grateful, your lordship.
अगर cancel ही हो गया है तो infructuous हो गया.
$77, my lord. I am for the accused person in item number 77.
78 and 79, I am appearing on behalf of the accused person.
Next, it is on 12th of April.
The accused are appearing and cooperating with the trial.
They are appearing, but 6 persons are left. Those who have made the 164, let them not be exactly.
Yes, they are appearing too. Opposite party accused are appearing in trial, appearing regularly and cooperating with the trial court. Report shows trial is in progress. Other vulnerable witnesses are yet to be examined. Let the applications be adjourned. Be adjourned, and the applications. Let the matters be adjourned and fixed in the monthly list of and appear in the monthly list of May 2024. Further report with regard. When is the next date?
12th of April.
12th of April. Then matter will appear 1 week after vacation.
The further direction for fixing the schedule be passed because
The trial court is requested to fix schedules at short intervals and conclude the trial as expeditiously. 1 week after summer vacation.
Great, Your Lordship.
Next.
On 80 Act instructed today is the date for evidence of the investigating officer.
We will drop the proceedings. Trial has substantially progressed. Vulnerable witnesses have already been examined. Today is the date for examination of the investigating officer. Under such circumstances, we do not find any reason to cancel the bail. Now, opposite party accused has cooperated during trial. Under such circumstances, we do not find any reason to cancel his bail. Application is disposed of.
Grateful.
Next.
I'm for the petitioner.
Was it party number 2, Lord?
Well, last occasion, Your Lordship called for a report from the state. My Lordship kindly have a look into the report.
Trial is going on, PW5 was already completed and next date is on 3rd of April. for trial.
All right. Report is placed on record. Trial is in progress. Opposite parties are cooperating with the trial court. Let the matter appear in the monthly list of May or
June.
after June. 1 week after summer vacation. For the report with regard to status of the proceeding be filed. Opposite party accused shall continue to cooperate with the trial court.
Grateful, Lord.
Next.
Lord, for the petitioner. Lord, the file, Your Lordship would kindly see the impugned order for a moment, Lord. The learned judge has recorded there is eyewitness, there is 161 statement, there are specific allegation, but
not convicting, he's just acquitting, he's just given bail. So
no, Lord, post bail conduct is also, Lord.
What post bail conduct is?
There is a.
Yes, Mr. Kollol Mondol.
Yes.
The client is threatening witnesses.
There is a specific
year of 2020.
In the year of 2020,
Yes. Followed it.
because of
The
COVID,
occasion,
he's threatening.
as per my learned brother, stated there bail was granted on 14/9. Thereafter, my lord, on the
September
16 and 17, 18 and 20. But that's all. But that every complaint a stereotype complaint. Kindly go through the
Where are the complaints?
At page 17, 18 and 19.
17, 18,
17 is 2020.
all.
The application was filed, Lord, in 2022.
Thereafter, there is no complaint.
Till date, Lord, it is not there because they are, Lord, defending a case of, Lord. Initially.
What is the stage of the trial?
Lordship, I need to take instruction, Lordship.
Charge has not been framed yet.
Why?
That, Lord.
Lordship.
All right. We dispose of the bail. What is there in it?
Your Lordship, kindly put some conditions, Lord, so that.
What condition?
They do not threat us again.
There is no threat. In September, there is threat.
Threat is always, Lord.
And your application is in 22. Threat is in May 2020 and application for cancellation in 22.
Lordship would kindly
That
see
is the degree
perversity
of
of
threat.
Lord, I have challenged the order also. Lord, order is also, Lord, your Lordship.
Order is all right. Order was passed in September 2020. You challenged it in 22. Why should we go into this perversity? These are orders. True, they are of substance, intermediate, matters of moment. But they are not final orders acquitting a person. So it may not be, we won't substitute our discretion in place of the judge.
On the last occasion, your Lordship's desire. Yeah, has been
The court bail was rejected
by your Lordship, Lord. That is the reason, that is another reason, Lord, which prompted me to file.
No.
These
They are
persons.
now on bail, other co-accused?
No, they are on bail. They are not on bail. They are not on bail.
All right.
That is the reason your lordship lord said that your lordship would put
Where,
certain.
where did we cancel the bill? Where have we rejected? When we have we rejected?
the order copy, Lordship.
Your lordship has,
Show
that
us
is,
the order copy.
What is
that is
Mr.
Diwan.
Asif Diwan.
Asif. Mr. Diwan, Mr. Ahmed has not challenged the cancellation on that ground. You are supplementing that ground. He is not pleaded that co-accused bail have been rejected. Then now can you add to grounds when that was not the ground on which the challenge was made?
These are the orders, Lord, where your lordship has rejected the prayer for bail of the other co-accused.
Let us see.
This is one order of Dali.
144668. এটা মানে সবগুলো একসাথে কিন্তু দু সেট করে আছে
It has all been combined together, Lordship. Jani Alam Sheikh is also there, Lordship.
সাপ্লিমেন্টারি এফিডেভিট দিয়েছিলাম তো আমরা। এটা একটা সেট।
অ্যান্টিসিপেটরি বেল তো কোথায় ক্যান্সেলেশন?
Bail is also 439.
Dalim we have rejected.
Dalim, your lordship has rejected.
Jani Alam Sheikh also, Lordship, has rejected, Lordship.
Zakir Mondal has also rejected. Yeah. Selim Sheikh. এটা my lord justice
Bail prayer was rejected in 2022. You find these.
Dalim was rejected in 2021, 18/3/2021.
Correct.
Now, this is the order of 18/3/2021 was the order passed by Malad Justice Tendon and
all right.
Malad Justice
Record.
So,
order dated
18/3/2020.
9/2020, granting bail to opposite party number 2. To 4 has been assailed. Learned counsel for the petitioner contents. The court failed to consider the gravity of the accusation and was swayed by the submission of the opposite party opposite party accused numbers 2 to 4 that the victim suffered injury due to fall on a wooden log. Stop. After being released on bail, opposite party number 2 to 4 have threatened the petitioner on a number of occasions. Hence, their bail may be cancelled. Learned lawyer for state contents, bail prayer of co-accused, namely Dalim Sheikh, Jane Alam Sheikh,
Dalim Sheikh's সাথে another আছে।
Zakir Mondal, Ismail Mondal, Zakir Mondal,
Zakir is 438.
and others were rejected by coordinate benches of this court. Learned lawyer for opposite party number 224, Contempt. Bail was granted in September 2020. Learned judge had considered the case diary and materials on record and thereafter released opposite party number 224 on bail. The said order has been challenged after a lapse of 2 years in 2022. Allegation of misuse of liberty are fictitious, are figments of imagination and relate to complaints made in 2020. Eta bole tarpore, however, the bail order has been challenged in 2022. We have considered the materials on record. Opposite party number 224 were released on bail.
Initially, my lord, the order was challenged in 2020 itself. But since my lord, the certified copies were illegible, your lordship my lord, was kind enough to grant me liberty. That order is at page 10.
Yes. By the learned, opposite party number 224 were released on bail on in September 2020. The order was initially, the bail order was initially challenged in November. Initially challenged in 2020 itself, but came to be dismissed as the documents annexed to the petition were illegible. Liberty was given to file afresh. Accordingly, petitioner has filed the present application in 2022. Stop. We have perused the impugned order. Full stop. The order records the submissions made by the respective parties. Or the order shows the judge had considered the submissions of the respective parties, gone through the materials on record, including the case diary, and released the petitioner on bail. Said order had been passed in 2020. Full stop. 2 years have lapsed since then. Under such circumstances, we are not inclined to examine the order. 2 years have lapsed since then. It cannot be said that under such circumstances, we are not inclined to substitute the discretion of the trial judge to grant bail to opposite party number 2 to 4. Full stop. It is strenuously argued bail prayer of co-accused had been rejected by various coordinate benches of this court. It is trite, rejection of bail. The parameters of rejection of bail do not stand on the same, are not same as that pertaining to cancellation of bail. Hence, we are not persuaded by this submission also. On the score of misuse of liberty, we have gone through the documents annexed to the petition. All the complaints pertain to 2020 and the allegations of misuse are general and omnibus. No contemporaneous complaint with regard to misuse of liberty is placed on record. Hence, no convincing case of misuse of liberty justifying cancellation of bail is made out. Accordingly, we are not justified. However, to instill confidence in the mind of the petitioner and his witnesses, we propose to subject the opposite party number 224 to conditions. Opposite party number 224 while on bail. Now, in addition to the conditions of bail already imposed upon opposite party number 224, the said opposite parties, while on bail, shall not enter Ausgram police station until further orders. They shall provide the address where they shall reside to the investigator and the court below and report to the officer in charge. Sure. उसमें 2020 में भेजा है 22 में कैंसिल करेगा Oh, 24 hey ওটা 2024 after lapse of 4 years মানে বলেছেন after lapse of 2 years later 4
Yes. An order passed by the learned vacation judge at Alipur, Malad, is under challenge. Now, Malad, 10 persons Malad, were named in the FIR, 10 charge sheeted. Now, Malad, 7 are still absconding, and these 3 persons, Malad, Ashmat, Noor Hussain, and Abul, they are the principal accused persons. Malad, the allegations in the FIR 161 statement of the injured say that Ashmat shot Noor Hussain and Abul Malad, they hurled bombs. Now, Malad, kindly sees the order of the learned sessions judge. But 7 are still absconding.
How long they were in custody?
Malad, my instructions are, Malad, they were in custody, were arrested on 8th of April, granted bail on 11th of October 2022.
More than
6 months they were in custody.
Malad, rest are still absconding. Kindly consider.
Their abscondence is a justification to take these persons back in jail.
Malad, kindly sees their role. Malad, there is one
We are
person
not-
died,
we are
one
not
was injured.
hearing an order of acquittal, sir. We're just considering a discretionary order where after 6 months someone has been enlarged on bail because trial did not proceed, others are absconding. Whether we in the place of the judge would grant that or not is not the question. Is this an order which is within the realm of subjective discretion?
And Malad,
or
the
it is
post, Malad,
completely
my
purpose?
other
We don't
aspect
hold
is post bail conduct.
that. The post, where is
Malad,
post-
kindly comes to my affidavit in reply, Malad. I have annexed all the general diaries. Malad, page 13. Malad, we are being threatened. Malad, the injured eyewitness is being threatened.
All right. Opposite party, petitioner has assailed order dated
report, progress report, 24th of July has been changed for criminal.
of order dated 11/10/2022 granting bail to opposite party numbers 234 has been assailed. Learned counsel submit opposite party number 2 is the principal accused who fired at the victim.
Lordship.
There are serious allegations against 3 and 4 also. Ignoring the gravity of the accusation, the judge granted bail. Thereafter, opposite parties have threatened the petitioner and other witnesses. Accordingly, prays for cancellation of bail. Learned lawyer for state submits report. From the report, it appears date has been fixed for consideration of charge in July 2024. We have considered the materials on record, full stop. It is true there are serious allegations against opposite parties number 2 to 4 hearing. Full stop. However, they were in custody for a considerable period of time. Noting these aspects, the trial judge enlarged them on bail. It cannot be said that under such circumstances, we cannot come to a conclusion that the trial judge had acted in a perverse manner. Full stop. Acted in a perverse manner. With regard to the allegations of misuse of liberty, we find we have gone through the letters, complaint letters. They are general and omnibus and do not lay down specific particulars with regard to the nature of threat. Full stop. Hence, we are not inclined to take cognizance of these complaints and cancel the bail to opposite party number 2 to 4. Full stop. However, to instill confidence and ensure due supervision upon opposite party number 2 to 4 hearing, we direct the said opposite parties shall meet the officer in charge, while on bail shall meet officer in charge Kulpi police station once in a fortnight until further orders. They shall also appear before the trial court on every date of hearing and shall not seek unnecessary adjournment. In the event they fail to do so, opposite trial court shall be at liberty to cancel their bail in accordance with. Next.
This is an application by the state for cancellation of the bail granted in December 2022 to 3 accused persons who are the opposite party numbers 1 to 3.
Yes.
My lord, in this matter, my lord, your lordships would perhaps recall, this is the case where the victim had been taken to the hospital by the accused persons, by the OPs.
Oh,
my
yes.
lord,
That has been framed.
My lord, PW1 has been examined. 37 charge sheet witnesses are there.
It's for evidence 26th, 29th, 30th April and 2nd May.
All right. We will
de facto complaint, brother.
Report is placed on record. Trial has commenced and date and schedule for examination of have been fixed from 26th April 2024 to 2nd of May 2024. Opposite
PW1 has been examined, my lord, the complainant brother.
Opposite party shall cooperate with the trial court and shall not seek unnecessary adjournment. Further report be filed on the adjourned date. Matter will appear 1 week after summer vacation.
Yes.
Malad, I am for the petitioner. Malad, it's a case of 302. Malad, on.
Sir, I am praying not today on behalf of Mr. Rudrodipto.
What happened to Mr. Rudrodipto?
He is in code number 14.
So,
Malad, it's a case of 302. Malad, the learned court below grants bail. Malad, another co-accused person comes to before your lordship. Malad, your lordship cancels bail as well as rejected the co-accused person. Malad, 1 second the learned court below grants bail. Malad, this is the situation. Malad, your lordship would understand. Malad,
as discretion to grant bail.
Malad, this if in this way, Malad, this discretion. Malad, I have already submitted.
Where is
it's in your lordship's brief.
Oi.
There is a chart.
My officer is handicapped.
Malad, I have another copy. I have another copy, but there is only one single.
কি বল আলাদা আলাদা করে দিতে বলছি না অর্ডার শিটটা আলাদা থাকবে না অনেক ম্যাটার ছিল বলে করতে পারো না ট্রেনিং 55 year old totally perfect, sir.
The report regarding progress of trial, my lord.
None of us pass any exam.
My Your Lordship would see it from 1st March 2021, this list.
Hmm.
For Riazul Sheikh preferred a bail application which was rejected. Page number 21-22. My lord, thereafter, my lord, on 3rd August, Sikkim Sheikh Samsul Haq preferred a bail application. This honorable court rejected by Your Lordship's bench. My lord, that is at page number 23-24. My lord, then one Piarul Sheikh preferred a bail application. That was also rejected. My lord, thereafter, one Sanaul Sheikh got bail from the learned court below, who stands on the similar footing with those persons. My lord, taking cue of that, my lord, one Samsul Haq once again approached this honorable court. My lord, Your Lordship issued a suo motu rule. My lord rejected that Samsul Haq's application as well as cancelled bail of this Sanaul. My lord, thereafter, my lord, once again, my lord, this opposite party number 2, my lord, surrendered after 2 years. My lord, within 57 days, my lord, this bail has been granted.
Who is opposite party number 2?
My lord, in this application, my lord, this Sabiruddin Sheikh.
Sabiruddin.
Page 36.
So he was absconding. Huh?
But after 2 years, my lord.
He was absconding. Yes, Miss Gomes.
Yes, sir. He was absconding for 2 years thereafter.
Then
He
there
surrendered and
serious
thereafter-
allegation he was absconding. Bail prayer of co-accused, similarly circumstances have been repeatedly rejected. Bail has been cancelled. Has these aspects been taken into consideration by the judge?
But post bail conduct is good. That's all I can say. After 2 years, he surrendered. It is not that he was arrested, he surrendered.
But-
Thereafter, he was granted bail.
Why he was granted bail? On what ground was he granted bail? That he has been kind enough to surrender.
My lord,
No, there
that
was
order is at page
some
number
justice.
36.
36 page.
36.
Actually, submit which I make on a page.
Charge submit.
Yeah,
Charge sheet submit.
submitted that.
After submission of charge sheet, all those things happen.
Years ago. Have contributed to the delay for 2 years. At least he should be there for 1 year.
Yes, your lordship would have done that definitely.
What is this?
But after that, lordship, his conduct is good.
My lord, this application is pending for quite a long time, my lord. Your lordship would also see that when this was filed.
That is why we are
Uh,
saying.
It's not that I have come.
No, we have never said that you have come later on. We are saying that if in the meantime some trial has progressed, we will condone these irregular.
Lordship, state has submitted report.
Now in 26 to 2024, evidence has PW1 has been examined.
Yes, started.
How many witnesses there? Sonali Das. And next is 1-4.
21.
21.
1-4 is there. Let us keep this matter after 7. Today is the date for examination of witnesses.
Your lordship wants to keep this alive, my lord.
No, we want to understand when the next date will be fixed. Today is the date. Original case diary is here.
No, my lord.
My lord, trial is going on.
So please give a report. What is the? We'll keep it after 7 days.
Yes, your lordship.
Let this matter appear. Report is placed on record. Today is fixed for recording evidence. Matter will appear 7 days hence. 1 week hence. Further report be filed on that.
Deep twist. কবে গো 8 তারিখে
CBI का cancellation up to 120 तो करो
Make please a lordship, my lord. I'm for the petition.
I'm for the private opposite parties.
We are dealing with you difficult only that case I think I try to give a little to the past. He is not. Into the thing. You understand? Yes, sir. Sir, how that day, yeah, he was saying, he immediately went to he was constituted of bail. Secondly, he was out. He filed suspension. He was there for about 2 months. Because of he says, हम चेक करा उम्र का है, हम बढ़ जाएगा ये करेगा।
Petition rate কপিটা দিবি তোদের যে ফার্দার ইনভেস্টিগেশন এর পিটিশনটা
করছে ওখানে তো আমরা
ওখানে করেছে না
হ্যাঁ ওখানে লোর করতে পেরেছি ঠিক আছে নিচ্ছে
I think the two important witnesses are not one is that servant was named scooter. He has not circuit. In a phone number. Mama, you don't know. Window.
a report was called by I am for the private opposite party.
Appearing alone now.
Only in this matter.
Only in this matter. Where is your senior? Huh?
This
Mr.
matter.
Ganguly?
He's on his legs in that. Millard, before my learned friend, Millard, just one thing, Millard, if I may point out to your lordships, kindly seize the last order passed by your lordships on 5th of February 2024. On that date, Millard, subject to correction, my learned friend had submitted before your lordship that he has taken out an application before the magistrate under 156(3) for monitoring the investigation following Sakiri Vasu, Millard. And on the basis of that submission, Millard, this order was passed by your lordships. Millard, subject to correction by my learned friend, Millard, we took instructions. Through our clients, we have got the records checked up. There is no 156(3) for monitoring the investigation, subject to correction by my learned friend. What we could find it that there is another 156(3) filed for a specific criminal case, and in respect of that 156(3), the order was passed as early as on 15th July 2023, and the case came to be registered on the basis of that order on 3rd of August 2023. So as on the last date, on 5th February 2024, when my learned friend was saying...
It has been filed.
Not yet. No. When my learned friend was saying that a monitoring petition is pending. Millard, what subject to correction? There was no such petition. What had happened in this case is, Millard, it was submitted by my learned friend that my resignation before on the basis of which I was resigned from the company, that has been lost. So therefore, no Millard, no comparison can be done. Therefore, I had made a prayer that there is an AOC4 form wherein all the bank state, all the PL accounts have been filed also in my name where my signature is forged. Therefore, a report.
So your signature is not there in any of your bank documents.
It is there, Millard.
So why doesn't the police collect that?
Millard, incriminating letter on which my signature is forged. It's their case that they've lost that.
Wow.
Right?
Then the forged document lost. What can be done?
Millard, is their case, Millard.
So their case means has it been recovered?
Millard, no.
So for cancellation, what we'll do with the cancellation?
Millard, my cancellation was also on the point. Millard will kindly seize the order. The first order wherein your lordship had remanded the matter back before the learned trial court was that it was at the stage of interim bail. Millard will kindly seize this case. Millard, they have again surrendered, and only because they have again filed a bail application saying that the previous application was not rejected on merits, they have been granted bail in this case.
Very good.
And Millard, my NCLT proceeding.
The court says that we cannot give any opinion. So
all right, you take steps to recover the original question document. If they are saying it is lost, he will accept it is lost.
They have lost diary and all that.
All right, so verify that fact. If it is lost, it is lost. And if it is even lost, the thing is, a case of forgery can be proved through circumstantial evidence. If a dead body is not recovered, corpus delicti not found, will you say that there is no murder? So if you can have circumstantial evidence on that, find out. But we are in a limited scope whether we'll cancel the bail or not. We will give another opportunity. You conduct further investigation. A report is placed on record.
Otherwise, if we are going to file, we are going to file charge sheet.
File a charge sheet.
But without that.
So what else? On what basis will you say that the document is forged? If you don't have the document on his ipsedix. What circumstance? All right. Further report is placed on record. Report shows the report of the handwriting expert is inconclusive. Learned counsel for the state submit. Investigation is still in progress. Let the matter appear 1 week after summer vacation.
We have concluded.
Have you filed charge sheet?
I am going to.
So the investigation is in progress. As per the definition of investigation, it is not complete. 1 week after vacation.
Kindly grant me liberty to file a supplementary opposition.
What else?
I
How
will
many
also, my lord,
oppositions
bring
will
some
you file?
documents on record, including these things, my lord, with regard to his submissions on the last occasion.
Liberty to file supplementary affidavit. Liberty is granted to opposite party accused to file supplementary affidavit. Placing on record additional documents.
I'm deep.
My lord.
Deep. 1 week.
Next.
Time for the petitioner. My lord, in this matter, the petitioner had challenged the order dated 23rd February 2023. My lord, on 2 grounds. My lord, the post bail conduct is bad, and my lord, the learned magistrate, while granting bail.
I am for the petitioner.
What is the petitioner done?
Page 26 onwards.
All right, let them stay outside jurisdiction. Petitioner has challenged order dated 23rd of February. Order dated 23rd of February 2023 granting bail to opposite party husband. Opposite party number 2 husband. It is contended opposite party number 2 after being released on bail has threatened the petitioner. Learned counsel for opposite party number 2 denies and disputes the allegations. We have considered the materials on record. Opposite party number 2 had, it is alleged opposite party number 2 had assaulted the petitioner over demands of dowry and had even tried to smother her with a pillow. Medical report does not support the allegation of smothering the petitioner with a pillow. All right, if there is smothering of pillow recorded, then medical reports do not show petitioner had been smothered with a pillow. In this background, whether the allegation of attempt to, whether opposite party number 2 had intention to murder the victim requires to be assessed during trial. Hence, we are not inclined to cancel the bail granted to opposite party number 2 on merits. On the score of misuse of liberty, we have gone through the allegations, we have gone through the letters of complaint. Taking into consideration the apprehension, the allegations made therein, we are of the opinion interest of justice would be served by subjecting opposite party by restricting the movement of opposite party number 2, so as to instill confidence in the mind of the petitioner and other witnesses. Accordingly, we dispose of the application by directing opposite party number 2 while on bail shall not enter Lapur police station until further orders. He shall provide the address where he shall reside to the investigating agency and the court below and report to officer in charge of the police station within whose jurisdiction he shall reside once in a week until further orders. Opposite party number 2 shall regularly appear before the trial court and shall not seek unnecessary adjournment. In the event he fails to do so, trial court shall be at liberty to cancel his bail without in accordance with law without reference. Next. Stop clearance.
My lord, I am for the petitioner, my lord, in this.
My lord, in the 88 to CRM 2H76.
Bail cancelled. Bail cancelled.
I am for the respondent number
Bail is cancelled.
1. I have prepared my
Your
affidavit.
bail is cancelled, Mr. Prahlatka. Your client's bail is cancelled.
Copy. Look, nothing against them. That's why.
Nothing against them.
My lord, specific
Trafficker of women.
No, they were not there.
They were not there. Their main agents, servants were there.
Identified specific role by victim girl 1, 2, and 3.
One by one, একটু পড়ুন আপনি দেখুন তারপরে may I please
My lord, may I please mic his.
No, Prahlatka is opposite party number 2 has the right to place his case first. You are opposite party number 2.
Yes, one in 2H76.
How many cases are against you?
Only one.
Only one?
Yes.
Different accused.
Different accused.
Accused, so two different applications.
Same case.
Same case.
But I am in 89, which will be my lord.
You are alone. You are alone.
I am the customer.
You are the customer, so your bail will not be cancelled.
My role, I'm for the opposite party number 3 in item number 88. My role also has been attributed as the customer.
What customer? You are procurer of customer, pimp. Customer. Huh.
My lord, what happened in
and
this?
Prahlatka and you are the main player running the brothel.
Well, I am the person who has sought for cancellation.
You have sought for cancellation. So, what is the victims have been examined?
Yes.
Then what is the use of cancellation?
Next date is fixed on 4th of June.
That is the count. Planet would be granted bail. 2 victim girls were examined.
All right, let us keep this matter after the next schedule.
Next schedule is 4th June.
4th June.
We will ensure all witnesses. Are you going to the trial court?
No, I'm not. My
Thank goodness. Otherwise, trial will never end.
My lord, that's the point we were trying to.
We will monitor that. Don't worry. We will injunct you from cross-examining the
I'll be happy.
witness, particularly police officer.
My learned friend, who assists me always there, he's junior. He's
Who
there.
is assisting you?
He's from the legal aid.
You were from legal aid?
No, from this another learned
So
friend.
if a man is from legal aid, why you are going and
No, I'm
acting as
not.
senior?
I'm before this court only. Not
Oh.
He just
So
requested me.
before this court, you are appearing for consideration and they are legal aid.
Yes.
Huh? Opposite, it is contended on behalf of the petitioner that opposite party accused were involved in trafficking women for sexual exploitation. Evidence of the witnesses,
all the victims,
evidence of the victims disclose their role in the crime. Learned lawyer, hence their bail may be cancelled. Learned lawyer for opposite party or for opposite parties in CRMDB 2876/2023 submit. Vulnerable witnesses have been examined and there is no apprehension of winning over the remaining witnesses. learned lawyer for opposite party in CRM DB 2879/2023 submit. He was a mere customer and was enlarged on bail. Learned lawyer for the state contents next schedule is fixed. Next schedule for examination of witnesses 4th June 2024. We have considered the rival submissions of the parties. Though allegations involve an organized crime, we note vulnerable witnesses have already been examined. However, to monitor smooth progress of the proceeding, we adjourn the hearing of the matter till 3 weeks after summer vacation, 4 weeks after summer vacation. Trial court is requested to proceed with the trial expeditiously. All the parties, including the opposite party accused, shall cooperate with the trial court in that regard. No witness by in chief completed that day, clause has to be completed.
No, that is being done.
Yes.
That is being done.
5-day clause.
No, no, not.
No. 1,000 questions.
No, not all. No, not to everyone.
Bacho.
Yes, CBI, Amajit De.
My lord, I am for the respondent number 1 and 2.
Now all proceedings state.
In the matter, 18th April is the next day.
All right. Learned counsel for CBI submit proceedings. They have approached the Apex Court, praying for transfer of the proceedings. Honorable Apex Court has stayed the proceedings. Under such circumstances, we adjourn hearing of the matter 1 week after summer vacation. Report be filed on the adjourned day. Sir. ये देख आदमी सब ठीक है।
और 91, 101.
सब केस दिल्ली में।
91 to 101, I appeal for the opposite party except 95.
Same order, same order. 102. Yes, next matter.
Or I for the opposite party number 2.
Who is for petitioner?
The petitioner's premise for coming before your lordship was
I am appearing for the
petition. Was ignored by the learned magistrate. However, the charge sheet has already dropped the charges of 330. That was probably not known to the petitioner at that.
You file affidavit.
Charge sheet has been submitted.
You file your affidavit.
330.
Affidavit in
Dropped
opposition.
in charge sheet.
My lord, we did not know that.
All right, let him file the
Yes,
affidavit.
my lord, definitely.
Affidavit in opposition we file within 4 weeks, reply 2 weeks, matter will appear.
After 8 weeks.
Wait, 4 weeks, 2 weeks,
8 weeks.
all right. 7 weeks.
Deep load.
Next matter.
Hey, वो करा था उठे।
Yes, Mr. Mukherjee.
My lord, on the last occasion, I paid for bail, suspension of sentence. Earlier, it was rejected. Your lordship directed preparation of paper books, but I don't file. What is the reply?
By tomorrow, it will be prepared. The department told me.
My lord, only one problem is there. My lord, I am appearing for the 2 persons who are in custody. My lord, other persons have appeared who are on bail.
Let the paper book first come. Women बोलो काल के आसबे.
So I have to collect also. Paper books have come.
Please correct. Who are the other lawyers?
My lord, at that time, my lord, Mr. Shivaji Das was appearing on behalf of the petitioner. My lord.
Who is for state?
মঙ্গলা সর্দার
103, 103. Mr. Das, appear for state. Mr. Mukherjee, you collect ask your junior to collect the paper book
on behalf of these
for
two.
1 and 2, 1 and 6.
Yes.
And who is the lawyer who represented Shivaji Das?
Yes.
Can you inform Shivaji Das?
I will.
We are keeping it next week,
Next week.
1 week.
Yes, my lord.
We are not commencing the hearing.
Yes, my lord.
Let Mr. Shivaji Das come.
And thereafter, your lordship
Thereafter
fixes
we'll
a
fix a date.
fix a date, and your lordship takes up
Yes.
this.
1 week. Adjourn for a week. Paper books be collected.
Next Monday, my lord.
Notice be issued upon learned counsels representing opposite parties number 2 to 5 who are on bail. Matter will appear
Next week, my lord. Next Monday.
We are requesting you to issue the notice.
Yes, my lord. I will inform them.
Learned counsel for Mr. Mukherjee assures the court to inform learned counsel appearing for appellate number 2 to 5 with regard to the next date of hearing.
I will, my lord. Great.
Next.
এটা কি রে? এটা একটু রেকর্ড।
Apart from Basas.
My lord, I am for the appellant number 4.
Extra pressure. Over 115.
My lord, there are 4 appellants. I am for the appellant number 4. My lord, I am in out of 4, my lord, 2 were granted.
I am telling you, we will depend on the if you think that you are doing prices, you are looking for everything. Correct. Just do it for the pleasure of it. The fact that you are helping people to get something. And you know the lawyers to get it. What am I saying? You are in responsibility.
And 5. 5 এর সাথে সাপ্লিট একটু দেন।
ऑर्डर होगा बोलिए नहीं ऐसे नहीं होता है भैया यू आर biggest mistake waiting that's the quality in the there has to be motivated to service you are creating promotion it is profit orientation profit orientation is good for the commercial
কি নাম যে মূল যে অ্যাডভোকেট অন রেকর্ড তার কি নাম ছিল?
which is sovereign that is independent and which is service this is my view
পূজা সামথিং ছিল পূজা গোস্বামী না
I don't know. Paper book is ready.
My lord, there are 4 appellants. I am for the appellant number 4. My lord, out of 4, 2 were granted bail by your lordships, my lord, in 2018 itself, my lord. Now, my lord, my difficulty is appellant number 4. He is in custody for 6 years and 4 months. Lord, the difficulty is that he has lost his wife on 23rd of January 2024.
Given interim bail.
Lordships, and he has 2 minor daughters, my lord, 6 years and 16 years, and there's no one.
That we cannot wait for the minor daughter to become major.
No, my lord.
We can give you a month's interim bail
Lordships.
to attend your wife's last rites and all.
No, I was granted a short parole to perform the burial and final rites, my lord. But my daughters, my lord, and my appeal is otherwise ready, my lord. If your lordships are inclined to, my lord, I am, my lord, prepared to, my lord, argue the appeal, my lord, if your lordships desire. But there are 3 more appellants.
To ask them to appear, then we will fix
Lordships.
the hearing.
Mr. Mitter had initially appeared, but there was definitely an advocate on record, so I'll.
Who is the advocate on record?
I find, my lord, from the cause title of the memorandum of appeal, a lady,
And Pooja Goswami.
Pooja Goswami, had signed the.
Pooja and Sreyashi. Please inform Ms. Sreyashi Vishwesh and Pooja
Lordship.
Goswami.
I'll inform them, my lord. The case is based on circumstantial evidence, my lord.
Correct, but then it's a case of murder. We have rejected the bail prayer
Lordships.
earlier.
Lordships.
We are not going to suspend the sentence when
My
you are
lord,
6
I
years
understand.
in.
I understand, my lord. The lordship hears out my appeal, my lord. Otherwise.
Yeah, so we'll fix it. Let it come up in the hearing list, and thereafter we'll see.
My lord, can I notify the learned lawyers for the other appellants, and your lordship may be minded to take it up next week once
Books are ready.
to consider an interim bail?
Interim bail, we are not interim. You already got a parole. Why
About
should
7 days, my lord. For 7 days.
So what more do you need?
My lord, I have to, my lord, make some arrangements with regard to my 2 minor daughters.
Take out an application stating that?
I've taken out an application.
Where have you
My lord, CRAN 5 and the supplementary affidavit that I filed today, my lord. CRAN 5 is my application for suspension. In CRAN 5, I've filed a supplementary affidavit, my lord. And I've pleaded everything, I've annexed all the documents.
CRAN CRAN 5.
But kindly takes the supplementary affidavit, which I have filed today, my lord. There, my lord, your lordships will find Annexure B is the birth certificate of my first daughter. Page 9 is the second daughter.
Wife died.
My wife died, my lord, in January 2024. It is at page 13, my lord. Death certificate of my wife.
Now it is April. So what will you do? The appellant
number 4.
Appellant number 4 has prayed for suspension of sentence. He contends his wife had passed away, that his wife passed away in January 2024. She used to take care of their minor daughters. He prays for interim bail to make arrangements for the care of the said daughter, of his daughters. Learned lawyer who is for state. Where are they? Learned lawyer for state oppose the bail prayer. We have considered the bail prayer of appellant number 4 was rejected on merits earlier. Good stuff. Paper books are ready for hearing. Under such circumstances, his wife had expired in January 2024 when he had been granted parole to attend her last rites. Under such circumstances, grant of interim bail with respect under such circumstances, after a lapse of 3 months, we are understand, after a lapse of 3 months, we are not inclined to grant interim bail to the appellant again on the score of making arrangements for the custody of his minor daughters. Full stop. Let the matter appear under the heading in the list of hearing 2 weeks hence.
can it appear as to be mentioned so that the other lawyers
All
can be
right, let it
notified and
appear under the heading to be mentioned 2 weeks hence. Then
I'm
let-
deeply obliged. I'm
to
deeply
give
obliged.
notify Mr.
I will.
Commissioner
I
if
will.
she is appearing, let them appear. I then touch.
Notify. I'm deeply obliged. Deeply. ঠিক আছে হিয়ারিং করে নিন। আমাদের ভালো মামলা কি? Great.
Yes.
But,
Next matter.
105 my lord, I appear for the appellate my lord.
Yes.
Lord, 198 to 302 my lord, conviction, life life imprisonment. Appellate number 1 is the husband. The appellate number 2 and 3 are the sons from his previous marriage. Now, my lord, appellate number 4 is the wife of the appellate number 3. Now, my lord, appellate number 2 to 4 were all along on bail during the trial period. Second marriage, this is the second marriage took place in 2015. Appellate number, I am not playing for bail with regard to appellate number 1. I am concerned about appellate number 2 to 4 only.
The lady was found tied to a tamarind tree
Yes, near the house.
in front of the house of the appellate's hearing. Beaten condition, the PM report, the doctor had find the details on the head. She was beaten mercilessly, and these appellants were
So-
part of the
So all family members will be convicted.
the allegations of the others from the deceased family was of torture and
What are the circumstances?
the circumstances, my lord, the oral evidence of the
All right, the oral evidence, they were torture.
they were tortured and the fact that the lady was found in front of the
That's all right.
in condition. That and there was no explanation from their side during the 330 examination. No DWs also.
Appellant's content, there is no direct evidence that
My learned friend has foregone the prayer for one, my lord.
they have no direct evidence. There is no direct evidence implicating them in the murder. Victim, housewife, wife of appellant number 1 was found in hanging condition.
Beaten up, tied to a
Hands are tied.
Wife of appellant number 1 was found tied to a tamarind tree in front of the house. PM doctor, full stop. Appellant number 2 and 3 are the sons of appellant number 1 from a previous marriage. Appellant number 4 is the wife of appellant number 3. They were on bail during trial. Appellant number 2 to 4 were on bail during trial. They did not misuse their liberty. Accordingly, appellants pray for bail. Learned lawyer for the state opposed the bail prayer. We have considered the evidence on record. PW 1,
1, 2, 4, 5. They are the
relations.
Relations.
PW 1 to 5 are the relations of the deceased. They deposed. Appellants tortured the victim housewife over dowry. A village shalish was also held. Subsequently, victim suffered homicidal death, where victim was found tied in front of a tamarind tree, tied to a tree in front of the house of the appellants. Full stop. Appellant number 1 is her husband. His involvement in the torture and demand for torture over dowry is clearly established. He was also present. He ordinarily he resided with his wife in the house, in the same room in the house. Other appellants, that is appellant number 224, are the sons. Other appellants, that is appellant number 2 and 3, are the sons of appellant number 1 from a previous marriage. Appellant number 4 is the wife of appellant number 3. Though they resided in the same house, extent of their involvement in the torture over dowry requires to be assessed during appeal. Mere presence in the event victim was found tied to a tree in front of the house. She had suffered homicidal death. Merely because a housewife suffers homicidal death at the matrimonial home, all the in-laws cannot be whether all in-laws can be held guilty of murder when the housewife is found dead in front of the matrimonial home requires to be assessed in the light of evidence. It requires to be assessed during the hearing of the appeal. Appellant number 2 to 4 has made out an arguable case in appeal. They were on bail during trial and did not misuse their liberty. Accordingly, we are inclined to suspend the sentence of appellant number 2 to 4 and enlarge them on bail. Bail prayer of appellant number 1 is rejected.
Grateful.
Paper books be prepared within 8 weeks. Next.
Next, my lord, the FNSC test that has been scheduled to be fixed on,
Which
my
one?
lord. Next one, my lord, the report.
They lead.
Well, the appellate number 2 is suffering from the
Right.
cancer. So your
No,
lordship
no,
must please.
All right, he wants some time.
8th April has been
8th
that
of
has been
April.
fixed
So
for, my lord.
We keep it after 3 weeks or 2 weeks?
2 weeks.
2 weeks. Adjourn 2 weeks. Medical report be placed on. Medical report of appellant number 3 be placed
Appellant
on.
number
record.
2.
Appellant number
2 be placed on record.
Great.
Next.
2 weeks. 2 weeks.
Wait, Adam.
My lord, I have served the copy upon the victim, my lord. C76 2G. My lord, initially
My lord. 107 তো 108 Nice. My lord, I am appearing on behalf of the appellant.
My lord, I am from the
Convicted
CBI.
under section 306, 330, my lord, term imprisonment, 8 years, more than 1 year.
330.
My lord, 330,
You
my
were
lord,
a police officer.
my lord,
Yes.
ex-police officer, my lord,
This
a
matter was
person
heard. Mr. Ahmed had
committed
argued on the
suicide
last
inside the
occasion.
correctional home, my
My
lord.
lords were
I was the officer in charge, ex-officer in charge of the police station. Now, my lord, 73 years old, my lord. He's in the custody for more than 1 year, my lord. On any strictest condition, my lord, kindly
What is the
appreciate.
sentence imposed? 10 years.
My lord, 8 years, my lord, 8 years. My lord, CBI, they have investigated, my lord, 306 on any strictest condition.
Supreme Court very recently said
Yes,
that
They are very
bail should be granted very
clearly.
sparingly in cases of
Kindly sees, my lord, here
custodial.
he
Presided
did
over
not
by
commit
Minor Justice
suicide
Hon'ble Bose.
inside the police station. He was produced, he was taken into the correctional home 3 days after, my lord. And my lord, National Human Rights Commission, they, my lord, made one inquiry and it was seen that inside the correctional home, he was asked to do some works, my lord, which was humiliating inside the correctional home. Thereafter, my lord, due to that humiliation, he committed suicide, my lord.
My lord,
This is
there are
not a
there are eyewitnesses, my lord, who have seen this police officer assaulting this
no, PW7 wife.
the deceased
No,
in
there
the
was-
inside the police station,
But
in the lockup. There is a doctor who says that this police officer pressurized him to create an
there
antedated
is-
fit certificate of the
but
deceased.
no injury in,
saying that he was
in
fit,
his body.
where
He committed suicide
severe
inside
injury.
the correctional home.
Yes,
Not
after
inside
this
the police
assault.
station.
And
After 3 days, he was produced. He
Inmates-
was taken into the correctional home. Thereafter, my lord, he committed suicide. There was no injury in his body.
inmates of the
And my lord,
correctional home also
PW7
said
is the
that he
wife.
was assaulted.
Is the wife, and he said, she
She
said,
is also an eyewitness.
she said that when she went to the police station, my lord, your lordship
also an
knows, my lord,
eyewitness.
in this matter, my lord, CBI, they took up investigation and they also submitted charge sheet under section 306. My lord, there is regarding 330, my lord, nothing is there, my lord, no injury. And my lord, PW3, what he said that he was compelled to give some certificates, my lord, that has no relation with this case. No relation.
That is precisely why my lords had called for the LCR. My lords wanted the this was heard on the last occasion.
More than 1 year I am in the custody, my lord. 73 years old, my lord, person. Kindly appreciates.
For announcement of
Page 6 of the judgment, PW7 saw.
PW7 is the wife, my lord, that I have said, my lord, wife. She said when she reached at the police station, she found that he was being assaulted. But my lord, the suicide is not due to that incident, my lord. 3 days after, inside the correctional home, he committed suicide. This is not a case that we have the appellant he assaulted and due to that assault he died. This is not the case. He committed suicide 3 days after.
There is a live link, my lord, between the suicide and the torture.
3-4 days after live link. Had it been a case that he committed suicide inside the police station, I could have understood.
This assault was on which day?
My lord, as per PW7, the assault is on 13th of February.
13th of February.
10th of February.
10th of February, or 10th or 12th, my lord.
And the arrest was shown on 11th. But all the witnesses say that he was
Information
apprehended
given
and picked up
regarding
on 10th.
suicide, that is on 17th February.
Yes.
And 17th February in the correctional home.
Yes, inside the correctional home.
Kindly see PW 9 and 11. The two other persons who were also arrested and were in the same lockup in the police station, they also say that they have seen this appellant assaulting this.
All right, there is proof of assault. Now, why he will commit suicide 7 days later in the correctional home?
Yes, my lord, yes.
because of the humiliation, torture, my lord, he was
after 7 days.
kindly see, my lord, it's not very far away, my lord. The dates are not very far away.
But then, was there any intervening event which also precipitated or contributed to the act of commission of suicide? He was not in the custody of the police officer at that time when he committed suicide, right? Appellant is a septuagenarian. He was on bail during trial, which spanned for 2 decades. He did not misuse his liberty. It is contended the victim had committed suicide in the correctional home and not in police custody. Under such, hence the appellant, custody. According sentence is one of term imprisonment. He has suffered incarceration for more than a year. He prays for suspension of sentence.
Not more than a year, my lord.
Not yes, more than a
February
year.
2023.
Yes.
Yes, my lord, I stand corrected. More than it. I stand corrected. I stand corrected. More than it. I stand corrected.
Wow.
I was reading it as 24.
Over enthusiasm. The learned lawyer for CBI contends appellant was the officer in charge of the police station concerned. He had illegally detained the victim on 10/2/2013, 98 and assaulted him. PW7, wife of the victim, and other inmates, PW 9 and 14.
9 and 11.
9 and 11 support the allegation of physical assault.
Another witness, PW 18, who was an inmate in the correctional home, he also says that he noticed that the deceased was, my lord, limping, and PW 18 asked the deceased, what has happened to you? And the deceased said that because of the assault, I am limping.
After 7 days in the correctional home, victim committed suicide. He prays for rejection of the prayer for suspension of sentence. He submits that petitioner is a police officer who had misused his position. Accordingly, his prayer for suspension of sentence may be dismissed.
And PW3 is a doctor of the Millard Block Primary Healthcare Center who was pressurized by this appellant to prepare an antedated document.
Forgery for that sentence, a bailable sentence.
True, my lord, but
forgery proved.
I'm just indicating to your lordship that this person was trying to
Hide
manufacture
the assault,
evidence.
Mr. Chatterjee. We are fully conscious. Hide the assault, but will the assault have the impact, or there may be supervening events in the meantime in the correctional home where he is not in custody when the suicide takes place?
Lord, sometimes, my lord, some events
we are here, Mr. Chatterjee, not in a contemplative jurisdiction, a jurisdiction of criminal liability. You have to prove it beyond doubt that it was the assault and the assault creating such a situation. An assault, if a person is assaulted, if he died, we would have accepted your submission. If a person commits suicide in police custody, still then the oppressive condition that he may be again assaulted is quite a compelling mental pressure. But once he is out of police custody, what was the circumstance in which he is? You have 18, no doubt. But this is a matter to be debated during appeals. কি বললেন? We have given anxious consideration to the submissions at the bar. No doubt, the case involves custodial violence by a police officer. There are evidence on record that appellant had assaulted the victim while he was in police custody. However, the assault occurred on 10/2/2000, 10 to
10/2/1998 and
10/2/1998. Thereafter, the victim had been remanded to a correctional home. After a lapse of 7 days, that is 17/2/1998, he committed suicide. Admittedly, the victim was not in the control and custody of the appellant when he had committed suicide. Whether the life link between alleged assault and the act of suicide when the victim was beyond the control and custody of the appellant has been established requires to be assessed during appeal. Appellant has made out an arguable case in appeal. He was on bail for more than 2 decades and did not misuse his liberty. He is a septuagenarian. Under such circumstances, we are inclined to suspend. A sentence is one of term imprisonment. Under such circumstances, we are inclined to suspend the sentence of the appellant.
Grateful, man. Grateful.
Paper books be prepared within 8 weeks.
I'm deeply.
Satisfaction টা দিয়ে দিচ্ছি
Defects in the LCR, key defect আছে দেখি। এ তো পুলিশ ডিফেক্ট কোথাও জীবনে ডিফেক্ট।
পুরুলিয়া, কোথায় সিজিএম পুরুলিয়া হবে বোধহয়।
I will die.
পুরুলিয়া দাদা।
CBI's appeal may also be, my lord. That has already been tagged.
There is a direction by the learned just reverse from the to bring the LCL.
পুরুলিয়া হবে।
The defects be removed and report be filed after 4 weeks.
আমরা
CBI for the acquittal on under
acquittal of a co-accused and for enhancement of sentence. My learned friend is appearing for the CBI.
For 10 years. From 8 to 10.
Yes. Wow. And acquittal of the other one.
Acquittal we are.
সব আছে আমি তাদের আমি দুটো তিনজনের রয়েছে। দিলীপ দাস, গোবিন্দ দাস, বিমান মাইতি।
CRA 96 এ আমি রেসপন্ডেন্ট, হ্যাঁ?
পুরুলিয়া, হ্যাঁ পুরুলিয়া। সিজিএম পুরুলিয়া হবে।
Yes, 110.
My lord, I am appearing, my lord. Allegations are under section 366 capital A,
66?
capital A 372, 373 IPC.
Tomorrow.
112.
Paper book is not there.
Oh, paper book paper book prepared হয়েছে নাকি? Not yet been prepared.
By tomorrow it will be ready.
Okay, by tomorrow. My lord, they are in the custody for more than 6 years, 6 months.
NP will consider after the paper book has come. 366A, procuring women for sexual exploitation.
We have not received a copy of the judgment.
You will receive a copy of the paper book, madam, by tomorrow. All right.
Grateful, my lord, grateful.
113 I am for the appellant, my lord. My lord, charge was under 498A 302, but 498A I was acquitted but convicted under 302.
Good enough.
My lord, I was all along on bail for a period of 15 years. I was on bail, my lord.
Does not matter.
So far as this, my lord, appellant is concerned, my lord, the PW1, the mother of the deceased lady, my lord, she was present in the matrimonial home, and in the FIR she says she alone was present. In the evidence she says that she was present along with her son PW2 and the minor daughter of the deceased Kushum Kumari. My lord, and this, my lord, is not there in the FIR. PW2, my lord, he has been declared hostile, the brother of the deceased.
Appellant contends that PW2, brother of the deceased, did not support the prosecution case. He was on bail during trial. He prays for suspension of sentence. Who is for state? Wife. You appear. Learned lawyer for the state opposed the prayer. She contends PW1, mother of the deceased, was present at the place of occurrence and deposed. Appellant had set the housewife on fire. PW13, PM doctor stated that
PW14 is the
PM doctor stated that appellant died due to burn injuries. We have considered the evidence on record. PW1 and 3 are eyewitnesses.
My lords.
1 and 3 are eyewitnesses. They were present at the residence of the appellant.
PW1 is the mother. She is an eyewitness. PW2, my lord, is the scribe, is the brother who was declared hostile.
The other?
PW3 is the scribe of the FIR. Then, my lord, PW4 is a neighbor who helped the deceased to be taken to the hospital.
PW1 is an eyewitness. She deposed. She was present in the matrimonial home of the victim at the time of occurrence.
And the neighbors say of the matrimonial home say the relationship between the husband and wife was very good.
You got drunk. You come beat up your wife, set her on fire. This is the nature of relationship. Present at the matrimonial home, she saw the incident with her own eyes. Her ocular version is corroborated by the by the PM doctor PW14. In view of the aforesaid evidence on overwhelming evidence on record and the gravity of the offense, we are not inclined to suspend the sentence. LCR has come.
No, my lord, it's a fresh appeal, my lord, not a very old.
Right.
I'm deep.
Next.
Deeply.
Paper books will be prepared within 8 weeks of receipt of LCR.
My lord, the victim.
Yes, Mr. Ahmed.
Lord.
Hey,
Ali.
Ali.
Lord, I am for the de facto complainant. Well, after taking that, we shall file that Bhogalat now in the department, my lord, in course of the tomorrow, my lord. We have got the Bhogalat now.
All right. When shall we keep it? Day after tomorrow. Wednesday, Mr. Ali. Wednesday.
Lord, may I file the affidavit of service?
Affidavit of service first. Next matter.
That I didn't know. Affidavit of service.
Yes, Mr. Vishal Kumar.
Conviction under section 302, Your Lordship.
So,
and I'm in custody for 14 years.
14 days?
14 years.
14 years.
Appeal was filed last year to 2023. There
So-
was a delay of 10 years.
So we are not going to suspend your sentence because you have been advised by certain co-convicts that if after 14 years you admit your guilt, pray for remission of sentence, we will consider it under the Sentence Remission Commission. Not here. After 10 years, come before the High Court and now ask for suspension of sentence. No. Law court records be called for?
It's already called for, my lord.
Yes.
Last order, it's already been called for.
Acha, paper books be placed on record. Matter will appear 4 weeks. Advise your client to apply for remission.
Actually, he does not have money.
Huh?
Does not have money. That
Why
is why he
remission,
could not
remission
file.
requires money.
No, he could not file the appeal because of which.
For 10 years. High Court Legal Aid Services do not operate for 10 years.
No steps were taken. Nobody gave him the information. That is what I told.
Every foot of judgment, it is endorsed that you have a right to prefer appeal through the High Court Legal Services.
Yes.
All right.
Nobody
Our
advised,
direction.
nobody advised him.
You don't require to advise. The judgment itself contains it.
As he's a khalasi, he's a
So he reads it. Someone, the welfare officer reads it to him. They are informed. They are to be informed that it's the direction given by this court. So all these stories are not there. You know why? The co-convict advises him. You know, now Supreme Court has given after 14 years, there will be suspension of sentence. So now you file appeal, they sentence suspended. They are more well versed in law than you.
That
all right.
And they know all the judgment.
Yes, they know the judgments, they know their judges, they know everything.
The views.
So this strategy will not operate. We have told you after 14 years, you can ask for remission. We will consider. But in the meantime, if you are kind enough to file your appeal, we will consider it and dispose it of. Come after 4 weeks, we'll dispose of the appeal.
Most obliged.
I did 10 years के बाद कौन सा आपका जजमेंट है ना वो तो सर्कुलेट हो गया 2 साल में चलो हाईकोर्ट में फाइल करते हैं वेट करके चले आए Yes, next matters.
Your Lordship, from item number 116 to 120, I am led by Mr. Kalyan Bandyopadhyay and Mr.
All right,
Shramukya
let the
Chaudhary.
matters appear 2 weeks after summer vacation. Other matters will take up, the appeal matters will take up tomorrow. This death reference we don't want to take up now. No? Next. Can you monthly score? What a death reference of monthly score? Sure. Other matters will take up tomorrow. Appeal we are not going to take up now.